Good morning. We are now on the record and we are video streaming, and I'm calling this evidentiary hearing to order. This is docket number 22 CONS 3115 CMSC, captioned in the matter of the application of Keto Inc. operator for an operator's license renewal. I'm Commissioner Andrew French. I'm serving as presiding officer for this hearing, and I'm joined by my fellow commissioner, Susan Duffy. At this time, we'll start with entries of appearance. And we will start first with counsel for commission staff.
Good morning, Commissioners. Kelsey Marsh on behalf of commission staff and the public generally.
Good morning, Mr. Marsh. And for operator Keto.
Good morning, Commissioner French. This is John Horst for operator Keto Inc.
Good morning, John. At this time, we'll move toward notice of this proceeding. Does staff have any recommendation regarding notice of the hearing?
Yes, notice of this hearing was contained in the presiding officer's November 8th order, setting an evidentiary hearing in this docket for Monday, December 19th, 2022, beginning at 9:00 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. Further, staff notes the operator and its counsel are in attendance today. Based on these facts, staff recommends the commission find notice is proper and that the commission has the jurisdiction to hear this matter at this time and place.
Thank you. Are there any objections to notice?
There are no objections to notice.
Hearing none, and based on staff's recommendation, I do find that notice is proper and that the commission has jurisdiction over this proceeding at this time and place. Let's now move to preliminary matters. First, let's discuss just briefly the procedure for these hearings on Zoom. We've been doing these for a while now, but I'd like to run through a few points. First, we are conducting this over Zoom, and sometimes things can go wrong. If a party encounters a technical issue, please just ask to go off the record, and then we can resolve that issue before going back on the record. Second, witnesses are asked to keep their microphones off or muted when they're not scheduled to talk. If everyone would please mute their cell phones, phones in their offices, and other electronic devices, that would be very much appreciated. Third, so that the parties are aware, if the commission needs to consult among themselves, we'll go off the record and the commission will enter into what's called a Zoom breakout room to discuss what we need to, and then we'll return from the breakout room and go back on the record. Fourth, since we're doing this by Zoom, please be especially careful to identify exactly what you're referring to when discussing pre-filed testimony and exhibits. And I do know we have some extra exhibits. So again, I think we've talked about it, but please be very careful to help us navigate exactly which document you're talking about. We do have copies of all of that on hand, so we should be able to follow along if we're careful. Now with that, do the parties have any other preliminary matters you wish to take up at this time before we move into the hearing?
Staff would have one preliminary matter, Commissioner French. As the commission may or may not be aware, Mr. Rodney Breeze is no longer with the employee of the commission, so staff is requesting that Ryan Dooling be allowed to adopt his testimony.
Is there any objection to that?
No, Commissioner French, we had agreed at the pre-hearing conference to allow Mr. Breeze's testimony to be admitted through Mr. Dooling's.
Very well. Well, we'll take that up when Mr. Dooling takes the stand. Are there any other preliminary matters?
Yes. On behalf of the operator.
Go ahead, Mr. Horst.
Commissioner French, at 7:11 a.m. this morning, or beginning at that time, the operator received the state's or the commission staff's proposed exhibits. I haven't had a chance to even count the exhibits, nor an opportunity to make any meaningful review of any of these proposed exhibits, the bulk of which appear to be inspections of the various leases operated by Keto Inc., conducted on November 30 and December 5, 2022. Well, looks like there's some on December 6, 2022. In fact, my secretary barely got them printed off prior to this hearing. To conduct a hearing today based on this information just received, which the operator has had absolutely no opportunity to meaningfully review, respond to, or prepare for at a hearing, is basically to conduct an evidentiary hearing by ambush. Further, based upon communications between Mr. McCann and Mr. Dooling that have recently occurred, it is the operator's understanding that District 3 staff is receptive to a meeting of staff and the operator to see what compliance issues remain and whether a compliance agreement could be achieved between the parties. We are talking about a substantial number of wells. So therefore, there are a number of compliance issues. In prior communications with litigation staff, I was advised that a compliance agreement was not, that the District 3 office was not amenable to a compliance agreement. I'm now under the understanding that that position has changed. For those reasons, we would, the operator would request that this matter be continued for an evidentiary hearing at such time as the operator has a reasonable opportunity to review the inspection reports recently conducted and to meet with District 3 staff to see if these issues can be addressed.
Thank you, Mr. Horst. What I'm inclined to do here is ask for a response from Mr. Marsh. I don't know if Mr. Marsh, do you need to confer with your client to discuss any of this, or is this all known to you?
Well, the email and exhibit sent this morning is known to me. I am unaware of any discussions between Mr. McCann and Mr. Dooling that would indicate that staff was willing to enter into any sort of agreement with Keto Inc. And none of that has been expressed to me at this point in time. And unless I'm mistaken, I believe that staff is still not willing to enter into any sort of agreement with Keto Inc. As far as the exhibits, staff was going to ask that the commission take administrative notice of its records. These are field reports that were conducted pursuant to some additional exhibits that Mr. McCann has provided within the past few weeks that was provided by Mr. Horst recently. I believe it was Friday after 5, so I didn't take a look at it till really late yesterday evening and this morning. So that is the purpose of those documents, and just to give the commission an update as to what the status of the leases were.
Well, I think I'm going to go ahead and I'm not going to necessarily make a ruling on admissibility of anything at this time. What I'm going to do is I am going to rule that we're going to move forward with the hearing. It's my understanding this proceeding has been open for more than a year. So until I'm advised by both parties together that they have some sort of deal, then I think we move forward with a hearing. As to each of the exhibits, I agree it is kind of tricky to find a cutoff date when the question is, whether the operator is currently in compliance. I understand operations are always changing, and so the parties rightfully probably want to update the record to some degree to inform us of whatever the latest breaking information is. I plan to give a little leeway with that, but understanding that we also have to observe, some rules of process here. So what I think we ought to do is take this on a case-by-case basis, Mr. Horst, and as exhibits are introduced for either party, if you have objections to any particular exhibit, please raise them at that time. So to be clear, the ruling would be we move forward, and then for each exhibit, if there are objections, raise them on a case-by-case basis as council attempts to introduce them. Are there any other preliminary matters?
Nothing from the operator.
All right. If Mr. Marsh does not have anything further, we will move forward to the examination of witnesses. Mr. Marsh, I believe you go first. You may call your first witness.
Do we want to make any opening statements,
Nope.
or do we just want to jump into?
I have
witnesses? I'm good with
totally,
either.
I have totally missed the opening statements. Let us begin with that. Mr. Marsh, you are first.
All right, thank you, Commissioner French. On September 2nd, 2021, the commission issued an order denying Keto's application for license. This denial was based on Keto's association with McSee Oil Company, which has unplugged wells on its expired license. And the denial also noted that at the time Keto submitted its license renewal, Keto incorrectly stated in its application that it was in full compliance with commission rules, regulations, orders, and enforcement agreements. The order denying Keto's application for license concluded that the license application did not meet the requirements of KSA 55-155C4, based on Keto's association with McSee Oil Company. And the commission also concluded that there was insufficient data to determine whether Keto was in compliance with all rules and regulations of the commission. While both parties have briefed the issue about Keto's responsibility for the wells on McSee Oil's license, we are before you today seeking determination whether Keto is in compliance with all rules and regulations of the commission. In March, commission staff conducted an inspection of all Keto's leases pursuant to the commission's March 8th order on briefing and requiring staff report and further investigation. Staff found violations at 98 of the 143 wells on Keto's license. Further, staff found 29 abandoned wells within a quarter mile of Keto's injection wells. It is staff's position that many of Keto's wells remain out of compliance with commission rules and regulations, and that the evidence previously provided by staff and the evidence presented today will demonstrate that. Thank you.
Mr. Horst.
Thank you. As Mr. Marsh has noted, this docket was opened on September 2, 2021, with the filing of the order denying application for license. That order recites, among other things, that denial of a license is a summary proceeding, and denial is considered a license revocation. In the order issued on September 2nd, excuse me, the commission made certain findings that on April 2, 2021, staff noted that staff notified Keto of a compliance issue involving McSee Oil Company, an entity which staff considers to be associated with Keto via a common officer or owner, Mark W. McCann. In paragraph 6, the order found that on June 1, 2020, Keto's license was suspended for non-compliance with commission's orders issued in docket numbers 19 CONS 3271 and 3272 CPIN. The conclusions of law contained in the order in paragraph 7 are that Keto does not meet the requirements of KSA 55-155C4 and KAR 82-3-120G2 because Keto and McSee have a common officer, director, partner, or member who is non-compliant. This issue is contested by Keto. The nature of the contested issue, construction of KSA 55-155, and the impact of Mark W. McCann's intervening personal bankruptcy have been fully briefed. In paragraph 8, the commission also entered a conclusion of law that it had insufficient data to determine if Keto is in compliance with all rules and regulations of the commission. Although the conclusion of law set forth in paragraph 8 of the September 2, 2021 order seems to Quito to be more in the nature of a finding of fact or a finding of negative fact than that the commission lacked data to determine Quito's compliance status. Quito simply notes that as of September 2, 2021, no specific compliance issues beyond the common officer issue were specifically raised. Quito timely appealed the order and has continued to operate various wells on various oil and gas leases under what might be described as an informal arrangement with commission staff. On January 14, 2022, commission staff and Quito filed stipulations of fact. Summarizing those stipulations, they address ownership of Quito and McSee, that Mark W. McCann is or was a common owner / officer of both, Mr. McCann's prior bankruptcy, issuance of the current operator's license to Quito on May 2, 2005, the prior license suspension in docket numbers 19 CONS 3271 and 3272 CPIN, the corrective action undertaken by Quito on 3 wells involved in those dockets, and the ultimate reinstatement of Quito's operator's license on July 29, 2020. The next significant event to occur was entry of the commission's order on briefing and requiring staff report and further investigation on March 8, 2022. The commission directed briefing on the 2 legal issues, bankruptcy and statutory construction, which has been submitted. The commission also directed that staff conduct a comprehensive review of commission records and Quito's leases and file a thorough report in this docket as to whether Quito is in compliance with all rules and regulations of the commission. That report was filed on April 29, 2022. The summary indicated that staff had found 176 wells on operators' leases, that 124 wells were found to be out of compliance, and that there were approximately 134 violations. At the commission's direction, Quito was asked to advise the commission as to whether or not it has complied with Chapter 55, all rules and regulations, and all commission orders and enforcement agreements. Quito filed its response on June 3rd, 2022. Summarized, that response noted that as of June 3, 2022, Quito has not received any notice of violation as to any of the wells listed in staff's investigation and report. Second, the wells listed in staff's investigation and report fall into 4 broad groups. 1, wells which need a temporary abandonment form CP 111 to be filed. 2, wells which are fully equipped and not subject to KAR 82-3-111. 3, wells not owned by Kansas Production Company, which Quito has no right to operate. And 4, wells which Quito needed to further investigate. In a nutshell, on June 3, 2022, Quito was the designated operator of wells which were then not in compliance, but those compliance issues could be addressed. Subsequent to June 3, 2022, commission staff and Quito have filed pre-filed testimony in this docket. What the evidence in this hearing will show is that as of today's date of hearing, Quito is in full compliance with Chapter 55 and all commission rules and regulations. Because Quito lacks access to COLAR, it has been required to submit all filings, correspondence, and supporting documents to the commission's office in paper form. If there are any instances where commission staff assert that Quito is not in compliance on a particular well, Quito has not been given a notice of violation with an opportunity to respond if Quito believes there is a good faith basis to disagree with staff. At a minimum, the evidence will demonstrate Quito's thorough good faith efforts to establish compliance, that any issues which may remain unresolved do not support a conclusion that Keto's license should be denied on those grounds. I would also call KSA 55-162 to the commission's attention. While the language of KSA 55-155 on license application or renewal recites that the applicant shall, quote, demonstrate to the commission's satisfaction that the applicant complies with all requirements of Chapter 55, all rules and regulations adopted thereunder, and all commission orders and enforcement agreements, end quote. That section is part of the broader act under Chapter 55 governing oil and gas operations in Kansas and must be read in conjunction with and harmonized with KSA 55-162, which directs the action the commission is to take if the commission finds a person has violated the provisions of Chapter 55 or the rules and regulations. Those actions include, but are not limited to, 1, order corrective action to remedy the violation. 2, shut the lease or well down until the violation is corrected. 3, order payment of costs and fees. 4, any combination of 1 through 3 above. Or 5, if the person does not comply with orders issued under 1, 2, 3, or 4 above, the commission may order the suspension or revocation issued pursuant to this act. In this docket, no notice of violation letters or notices have been issued to Keto. It has not been afforded the opportunity for hearing on appeal of any such specific notice. None of the corrective actions under 55-162, 1 through 3 have been ordered. Only after a failure by Keto of the actions under KSA 55-162 would a suspension or revocation of its operator's license be in order. Thank you.
Thank you, Mr. Horst. All right, now we will move to witnesses. Mr. Marsh, you may call your first witness.
Thank you, Commissioner French. Staff calls Ryan Dooling to the stand.
Morning, Mr. Dooling. Can I have you raise your right hand? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Marsh, witness is yours.
Thank you. Can you please state your full name for the record?
Ryan Dooling.
Mr. Dooling, by whom and in what capacity are you employed?
I'm employed by the Conservation Division of the Kansas Corporation Commission in the Chanute District 3 office as a compliance officer and environmental compliance and regulatory specialist.
And what is your work address?
137 East 21st Street in Chanute, Kansas.
Are you the same Ryan Dooling who caused to be filed in these consolidated dockets testimony consisting of 12 pages and 3 exhibits on September 7th, 2022, and rebuttal testimony consisting of 9 pages and 3 exhibits on October 19th, 2022?
Yes, sir.
Was this testimony created by you or at your direction?
Yes, sir.
Now that you're under oath, do you have any corrections to make to your testimony?
No, sir.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes.
Are you familiar with the testimony of Mr. Rodney Breeze?
Yes, sir.
And are you familiar with the field inspection reports referenced through Mr. Breeze's testimony?
Yes, sir.
At this time, staff moves for the admission of Mr. Ryan Dooling's pre-filed testimony and attached exhibits filed on September 7th, 2022 and October 19th, 2022 into the formal record.
No objection.
The referenced documents will be admitted into the official record.
Staff also moves for the admission of Mr. Rodney Breeze's pre-filed testimony from September 7th, 2022 into the formal record.
No objection.
Without objection, the referenced documents are admitted into the official record.
All right, thank you. At this time, staff tenders the witness for cross-examination.
All right, Mr. Horst, the witness is yours.
Good morning, Mr. Dooling.
Morning, sir.
Mr. Dooling, you are the compliance officer for District 3 Is that correct?
Yes, sir.
And you've held that position since April 2021.
Yes. Actually, it was later in 2021, Mr. Horst. It would have been probably November of 2021, I believe.
Do your duties as compliance officer include becoming familiar with the statutes under Chapter 55 and rules and regulations adopted by the commission governing oil and gas operations in Kansas?
Yes.
Do your duties also include becoming familiar with the forms and documents submitted to District 3 office concerning compliance?
Yes, sir.
Have you reviewed the reports prepared by Misters Triboulet, Breeze, and Logan in this matter?
Yes, sir, I have.
In your pre-filed testimony filed in this docket on September 7, 2022, you discuss KAR 823-403. And I would refer you to page 10, lines 5 through 15 of your testimony.
Okay.
Beginning on line 8 through line 11, there's quoted language out of KAR 823-403A5. Do you see that?
Yes, sir.
Does the quoted language set forth at that point apply to new applications to inject for disposal or enhanced oil recovery?
Yes.
Is there language in KAR 823-403 that makes the 1/4 mile area of review retroactively applicable to existing injection permits?
Staff believes it does. Yes.
Can you cite me to that language?
That language does not say existing injection wells.
But that is staff's interpretation of the regulation.
Yes, sir.
If there is not express language in 823-403 making the 1/4 mile area of review retroactively applicable to existing injection permits, how are operators to know that it applies to existing injection permits?
Bear with me just a second, please. The whole description of the 823-403 subsection 5 has a sentence in there. If deemed necessary by the Conservation Division to ensure the protection of fresh and usable water. That line right there states that we want to ensure protection of fresh and usable water at all times. So a new injection well that is proposed, or an injection well that is already authorized to be used at the time, if the well is found within a 1/4 mile AOR, it is our place to make sure that AOR abandoned well is not polluting fresh and usable water. So at that time, staff would recommend revocation of the use of that injection well until that well is brought into compliance. Not stating the operator has to bring that well into compliance, but until the abandoned well is brought into compliance, we would put a hold on the use of the existing injection well.
Mr. Dooling, do your duties as District 3 compliance officer include making determinations as to whether existing injection permits should be suspended or revoked?
No, sir, it does not.
Who is responsible for making that determination?
That would probably be in the UIC division of the Central Office in District 3 with recommendations from us and legal staff.
Would an operator who is adversely affected by such a determination be entitled to appeal and request a hearing before the commission?
That would be probably better directed towards legal. With that question, I would have to ask legal for the interpretation of that.
Until an order suspending or revoking injection authorization has been issued and becomes final, how can an operator be in violation of 82-3-403 as to an existing injection permit?
Repeat that, please.
Until an order suspending or revoking injection authority has been issued and becomes final, how can an operator be in violation of KAR 82-3-403?
At that time, there might not be a notice of violation since that operator until staff has found that there is a well in question.
Are you aware of any evidence of communication of fluids between any permitted injection wells operated by Keto and any of the abandoned wells identified in any of the staff reports filed in this docket?
The possibility is there. That's why there was those abandoned wells were mentioned in the lease inspections that staff performed.
But beyond the possibility, has there been any testing done to determine if there is any fluid communication?
No, sir, not at this time.
I'd like to turn to the McCann lease. In the report on the McCann lease, I grab that.
Mr. Horst, is this one of the exhibits you shared this morning?
This is not one of the exhibits. Oh, I shared the exhibits Friday afternoon, and then we discovered one exhibit that was omitted from the set that we mailed yesterday afternoon.
So this is the one labeled Keto Inc. McCann lease.
That would be correct.
Good.
And I am not sure, Commissioner French, that I have the ability to share that.
Let me, Mr. Myers, do you have that document in front of you, and are you able to share it on our screen?
I do. Mr. Horst, you do have the ability by hitting share screen down at the bottom of Zoom, but I have it pulled up. I can pull it up momentarily here. Hold on. Mr. Horace, is this what you were looking for?
That was very good. If we could turn to the exhibits marked McCann 002 and 003. And Mr. Dooling, can you see the form ACO 1 there designated as McCann 002 and 003?
Yeah, I see a well completion form for the McCann. I don't know I'm assuming that's 002.
Yes.
Okay.
And then if we can turn to McCann 004 and 005. And Mr. Dooling, can you observe that that is a well completion form for the McCann 2A well?
Yes, I can confirm that's a well completion form for the 2A, it appears. Yes.
So my first question would be, how did staff determine that it was the McCann 2A and McCann 3 wells that had been drilled out?
I would like to turn to our initial investigation. Mr. Myers, I have them listed as, exhibit KCC staff, but do you know which one is the McCann without me looking through them all?
Commissioner French, what's your preference for what I should do
Oh,
at the moment?
I'm sorry.
It's okay, no worries.
If Mr. Marsh could identify for us, although what I would like to keep in mind is this was Mr. Horst's examination. So Mr. Horst, is it okay if Mr. Dooling references us to another document within his testimony to answer your question?
Yes, that is fine.
Mr. Marsh, can you help us find where those may be located?
I think the McCann lease is documented in KCC or exhibit KCC staff 12.
Okay, one moment. I'll pull it up. Taking a moment for that to load onto my computer. As you can now see. Okay, this appears to be exhibit KCC staff 12 parties, page 1 of 9.
And John, if you would scroll down to page 2, please. Staff located 2 wells that were previously plugged on the lease. And when the lease investigation was done, we were found that those wells had been re-entered. Staff GPS those wells and matched them to the locations of the McCann 2A and the McCann 3. I contacted Mr. McCann. I believe it's in there, April 19th of 2022. I visited with Mr. McCann and had asked him if Quito had re-entered the McCann 2A and the McCann 3. And during that phone conversation, Mr. McCann stated that Quito had re-entered those 2 wells.
So, Mr. Dooling, again, back to my question, was the identification of the 2 wells based upon comparison of footage locations from existing records filed by the prior operator and the locations identified by GPS survey data?
That is correct, because we also located the actual McCann 2 and matched it up to the existing footages that were known. And it's definitely in a different location than where the locations for the 2A and the location for the 3 are where the wells were re-entered.
So, Mr. Dooling, in the report, it indicates that Quito failed to file notices of intent to drill on these 2 re-entered wells. Is that a correct summary of the report in your testimony?
I believe they actually filed for an intent on one of the 2 wells. However, Quito failed to notify district office that they would be re-entering. And neither well at the time of inspection had AC01 completion reports filed.
So, focusing on the notices of intent, let me start here. What are the data sources that provide information to the electronic records data management system that District 3 employs?
Would you repeat that question, please?
District 3 employs the ERDMS system as one of its tools to determine compliance. Is that correct?
RBDMS?
I'm sorry. RDBMS.
Oh, okay, RBDMS. Yes, sir.
Okay. And what are the data sources that provide information to RDBMS?
That RBDMS is a access database that tracks the forms like a intent to drill, AC01, all sorts of things. So I hope I'm understanding the question correctly, but that is an access database that we are able to investigate to see, you know, if a operator files a intent, it will be recorded on RBDMS.
Do you know how paper filings made by operators who do not have access to COLAR are integrated into the RDBMS system?
I would would refer that to the production department district or at central office, but I believe it's the operator mails it in and it is scanned and put in our BDMS.
So, Mr. Dooling, is it my understanding that, or let me ask this, did you check to see if two C1 notices of intent to drill had been paper filed in approximately October or November of 2021 by Quito on the McCann lease? And if so, what the wells the two C1s identified? I didn't say that very well. What wells those two C1s identified?
It looks like in my notes that there was a intent filed for the McCann 2 and the McCann 2A. I believe one of them was filed on 11/8 of 21, and the other one was filed on 11/3 of 21. But the wells that Quito re-entered were not the McCann 2 or the McCann 2A.
So is would it be correct to indicate that Quito filed two notices of intent to re-enter two wells, but it's staff's position that one of those notices of intent incorrectly identified the well, one of the wells that it ultimately re-entered?
Yes, I would agree with that.
On the McCann lease, the staff report also indicates that no spud calls were made. Who's responsible for logging spud calls at the District 3 office?
Most of the time our secretaries log all of the calls that they take. The only time other staff would log them if at the time the secretary was on the phone and it rolled over to one of her other ECRS positions phones, but 90% or better of the phone calls are all logged by our secretaries at District 3.
How's the record of the call maintained?
We have a log for each day. When an operator calls in, the information is taken down and placed on a daily log. So that way we can go back and review any calls that were made to the district office. And then at that time, after she logs it, we have a scheduling calendar. And that information is placed on the scheduling calendar. So if you was to call the office today and schedule a surface casing for tomorrow at 8 a.m., secretaries would note that on today's call log that it would be placed in today's call log that the operator called in a well today that will be planning on cementing the surface casing tomorrow at 8 a.m. So at that time, it would also go on a calendar for tomorrow, electronic calendar that is able to be accessed by all field staff.
So the determination that no spud calls were made on these two wells is based on a review of the log maintained by the District 3 office on a daily basis.
That is correct.
Mr. Dooling, in your pre-filed rebuttal testimony, you cited one violation of KAR 82-3-132, indicating that no notice was given by Quito before it entered a plugged or abandoned well. My question is, wouldn't the filing of the two notices of intent to drill constitute such notice under 82.3.103A1B.
Eighty-two, 132 states that every operator shall notify the Conservation Division or a district office at least 48 hours before re-entering an abandoned or plugged well.
Yes.
Mhm.
And in light of the fact that Keto Inc. filed 2 notices of intent on 2 abandoned wells, wouldn't the notice of intent constitute notice of its intent to enter a plugged or abandoned well?
It would show that they are following a intent to enter a well, but it does not state on that intent the day and time that they are planning to do it. That's why you have to notify the district office before operation begins.
Well, I know of no easy way to go through the rest of this, so bear with me. Mr. Myers, if we could pull up the Anderson exhibit, that would be AND 001 through 005.
One moment. Mr. Horace, this is the Anderson exhibit attached to one of your Friday emails. Is that correct?
Yes.
Okay, hold on.
Hello, can I be heard?
You cannot.
I would like a break.
Commissioner French, Mr. McCann asked whether he could be heard. Mr. Horace said you cannot. And when I went to stick Mr. McCann on mute, I heard it appeared to be he was requesting a breakout room with Mr. Horace. You might want to ask Mr. Horace whether he'd like to consult with his client.
I would like to consult with my client. Could we?
I will, we're getting on in about an hour here. I'm fine with taking a 5-minute break. And if the parties want to consult among themselves, we can do that. Do you have the ability just to call each other during our 5-minute break?
Yes.
Okay. All right. Well, we're gonna take a break until 10:05. And so at this time we are off the record in recess, and we will begin again at 10:05.
Parties, a reminder, we may still be streaming, so keep that in mind. Also, Mr. Horst, if you're still there, I have the exhibit ready when we return, if necessary.
John, thank you. I've muted myself.
All right, Jaden, I've got 10:05. All right. We are now back and we are back on the record. This is Commissioner French, and we will rejoin the examination of Mr. Dooling by Mr. Horst. Mr. Horst, go ahead.
Thank you. So, Mr. Dooling, I had asked Mr. Myers to pull up Keto Exhibit A&D, and if you would direct your attention to pages A&D 002 and 003. Is Mr. Dooling with us?
Yes, sir. I'm reviewing what's on the screen.
So, Mr. Dooling, according to Keto's records, it had furnished the letter identified as A&D 002 and the photograph identified as A&D 003 to depict that the Anderson #1 well was fully equipped and has run. Did District 3 receive this information?
District 3 did receive this information.
Unfortunately, I don't have access to the cover letter where, excuse me. So the letter was dated November 10. And would it be accurate that District 3 received this information within a few days after November 10, 2022?
I believe I have a copy of that actual with me, and I can tell you when the district office received it. Even though the letters dated November 10th, district office received a bunch of these on December 9th of 2022.
So, Mr. Dooling, I'm still not clear when District 3 received the November 10, 2022 letter.
We stamp everything that's received at their district office, and it was received at our district office on December 9th of 2022.
Thank you.
Yep.
If we can now turn to documents identified as A&D 004 and 005. And have you had a chance to look at those?
Yes, sir.
So the letter dated November 4, 2022 notifies the district office that Anderson #3 is fully equipped and has recently operated. And A&D 005 is a photograph of that well, correct?
Yes.
And do you know when District 3 office received this letter?
December 9th of 2022.
And it is my understanding, although I have not had an opportunity to review the exhibit, that the District 3 office has conducted an inspection of the Anderson lease recently. Is that correct?
That is correct.
And those results are being shared with the operator and its counsel this morning. Is that correct?
That is correct.
In other words, those inspection reports had not previously been shared with the operator?
I assume them are what the exhibits that Kelsey shared this morning. I did not ask Kelsey if that was what he shared, but I know I sent all of the field reports that we have compiled. I sent them over to him late Friday. So I'm assuming that that is the field reports that were received by you.
Accordingly, if there are any issues on the Anderson 1 or Anderson 3 wells, those issues are now being brought to the operator's attention on the date of this hearing. Is that correct?
Repeat that, please.
Let me rephrase that.
Okay.
Does District 3 office agree that the Anderson #1 well is fully equipped and capable of producing oil or capable of being operated?
No, sir. This well is fully equipped for production. However, there is no tank battery on the lease. This well was plumbed in to a plastic tank tote that was cracked at the bottom. So if the operator, I guess, did produce it, all the fluids are going to run onto the ground.
Is there a requirement under KAR 82-3-111 that a production well be plumbed into a tank battery for operational purposes?
It does not state that exactly the way you stated it. No, sir.
Is it physically possible to operate a production well and produce fluids into a temporary holding tank?
Is it possible?
Yes.
Is that? Yes, it's possible.
And can a well be fully equipped and meet the requirements for a demonstration well under KAR 82-3-111 while it is plumbed into a temporary holding tank?
Definitely not the one that was set in at the Anderson 1.
And again, the reason why the Anderson 1 does not qualify is because of the crack in the holding tank.
Well, yeah. I mean, if you turn the well on, oil is going to go all over the ground.
Let's talk about the Anderson 3. Is that well fully equipped and capable of production into a temporary holding tank?
Let me turn back to that, please. Hold on just a second. That well is totally equipped for production. And it is running into a portable tank.
So in your view, does the Anderson 3 well meet the requirements to comply or to satisfy it being a demonstration well under 82-3-111?
I think that's probably part of the reason we're here. In my view, no, it's not totally equipped for production because actually it is totally equipped for production. You can turn it on. If he put probably a little bit of gasoline in the gasoline powered motor at the time of inspection, it was empty. So at that time it could not run. But other than that, it was equipped with a small pump jack. I question if the tubing, if the rods was run to the production zone of that well, I'm not sure that well could be produced at the depth. That well was drilled with the pump jack that is assembled on that well.
In your opinion, then, does the Anderson 3 well comply with the requirements for a demonstration well or not?
The answer to that well is no, because it was not capable of merely resuming production because there was no fuel in the gasoline powered motor. So no, it does not meet those 5 criterias.
All right, Mr. Myers, I think we are done with that exhibit. If we can then turn to the Keto Inc. Beaver lease, which would be BEV 001 through 007.
It's being shared now.
Thank you. Before we go to the exhibit, Mr. Dooling, the staff's report on the Beaver lease indicated that there were 4 inactive wells located on the Beaver lease. And Mr. Triboulet was also recommending that the KL Beaver number 2 be drilled to table 1 and replugged as the well has cemented service, but is listed as producing on operator well inventory. Is that a correct summary of Mr. Triboulet's actions recommendations?
That is correct.
So with respect to the Beaver 1 well, is it correct that it has an active temporary abandonment approval that expires October 14, 2023?
The Beaver number 1, is that the
Correct.
one you're referring to?
Yes.
And could you repeat your question? I apologize.
Is it correct that there is an active temporary abandonment approved for that well, which expires on October 14, 2023?
That is correct. That TA was approved. However, after review of that on Friday, that TA will need to be revoked due to the well being shut in for longer than 10 years. I discussed some of that with Mark last Friday. There has not been any fluids put down that well for over 10 years. So that should not have been approved. But at this time, it is approved.
Let's turn to the Beaver 1A well, which would be Beaver 002 and 003 in these documents. So BEV 002 is a temporary abandonment well application, is that correct?
That is a TA application, that is correct.
And BEV 003 is a photograph of, is captioned Clark 5, but does that appear to be a photograph of the what's referred to as the Beaver 1A, or as Keto refers to it, the Clark 5 well?
Now, these beaver wells, I need to look at this because it is a little confusing because Quito has recently changed the well names on that lease. I'm not sure exactly why, but when I looked that up for that TA, he changed 2 well names on that lease here just recently, and I made a note of that because I believe the photos are not of that well, but that photo does appear to be of what staff knows the well as the 1A.
And according to the information I've been provided, this temporary abandonment well application and photograph of Clark 5 was sent to the District 3 office on December 6, 2022. Did District 3 office receive that temporary abandonment well application and photograph?
Before I answer that,
John, could you scroll that so I can see the signature / date? Thank you.
yes, I believe we received that TA. I do not know the exact date that it was received. I can't seem to find it, but I know we received that TA for the Beaver 1A. And it would have been sometime in December, but I can't seem to find that that actual copy of the TA application.
And has District 3 taken action to either approve or disapprove the TA application on the Beaver 1A well?
I would refer that question to Dallas Logan, who'll testify later, because I believe that well was denied. But I don't have a copy of that sitting right in front of me, but I believe both of the TAs were denied on the Beaver, but I do not wish that I had that copy. I believe it was denied because of one of the reasons was the shut-in date.
And do you know if Keto Inc. has received notice of denial?
If they have not received it, they should fairly soon. I believe that would have been denied on probably Thursday or Friday. So I do not know. A letter was sent, but I do not know if they've received it.
Let's turn next to document identified as BEV 006 and BEV 007. Mr. Dooling, BEV 006 is a temporary abandonment well application for the Beaver 3, known to Keto Inc. as the Clark 4, correct?
I would agree that we believe it's the Beaver 3, yes. And again, this is one I believe Mr. McCann had sent in to change the well name here in the last week or so.
With attached photograph. And so that my questions are the same on the Beaver 3 Clark 4. Has District 3 taken action to approve or deny the TA application?
Yes, that one there, I'm certain has been denied.
And does Keto Inc. know, or do you know when Keto Inc. was notified of a denial?
I believe that would have been Thursday or Friday that Dallas denied that one, so a letter would have went out for sure by Friday, last Friday.
Let's then turn to BEV 004 and 005. So, Mr. Dooling, in the report of Mr. AAA back in March, it referenced the KL Beaver number 2 well and indicated that it needed to be drilled to table 1 and replugged. Is that correct?
I'm sorry, I was trying to read this letter. What was the question again? I'm sorry, I was trying to read the letter that you had on the screen.
The report back in March 15 of 2022 by Mr. AAA indicated that the KL Beaver number 2 needed to be drilled to table 1 and replugged. Correct?
I'm looking for that report right now. That is correct. That is what his report says.
And that is because the well had cement at surface, but was listed as producing on.
That is correct.
Okay. And did District 3 staff have the prior record where this well had been plugged back in looks like 1986?
I am assuming not. There was because our record showed that Quito had it down as a active producing oil well.
So have you had an opportunity to see the October 5, 2022 letter BEV 004 and the plugging record BEV 005 before today's hearing?
No, sir.
Okay. And how would this type of information get integrated or get communicated to the District 3 office?
We usually, if this information was provided to the production department in Wichita, that information is scanned and put into RBDMS. That letter that you was referring to, I didn't see a well number, well name or anything on that letter. I just showed a letter that was talking about a well that was being plugged. So I'm not sure, if I would be in the production department, I wouldn't scan that and put it under, well, just, there was nothing that even notified on that letter that what well was plugged. But after production receives that information, it's scanned into RBDMS, and then it would be available for all field staff to be able to review. If that answers your question.
So the staff report of March 15, 2022 refers to a KL Beaver number sign 2 and identifies an API number.
That is correct.
Correct.
Yes,
And-
sir.
And the plugging report shows lease name KL Beaver and well number 2 at the top right-hand corner. Is that correct?
I don't know. I'd have to have you pull that back up because I do not have a copy of that plugin report in this field report. It looks like that. I'm assuming that is a number 2 on that plugin report.
That's what it looks like to me. Is there any offhand, do you have any reason to think that that this plugging report does not accurately indicate that this well was plugged by running cement from total depth to the surface?
Can you scroll down, please? I have no reason not to believe it. I still don't understand how it was Mr. McCann's producing this well if it is plugged. And I believe that's the reason it was noted out of violation, is he has it as a producing oil well on his well inventory.
In your experience as the compliance officer for District 3, have you ever had occasion to find errors on operators' well inventories?
Sure.
Is it conceivable that designation of this well as a producer was a clerical error on Quito's well inventory?
I don't like to speculate. It's a possibility. But there's been a lot of clerical errors then, I'm assuming.
Are you engaging in any level of speculation when District 3 staff indicates that the well needs to be drilled out because it's designated as a producer on the operator's well inventory?
If the well's plugged and was not called into the district office, a CP1 wasn't filed by Quito, we have no recollection if this well was cemented from bottom to top, other than the plug-in report that was that I've seen you show today.
Okay. And I can ask Mr. Triboulet this question too, but was there any physical evidence that this well had been drilled out at the time of the inspection?
No, this well, at the time of inspection, the cement was clearly at surface inside of the wellbore casing.
So in light of the fact that Quito did submit the plugging record to ensure that the commission had this record, can you now understand why Quito does not understand the need to drill the well back out to the depth of the deemed base of the fresh water?
If that plug-in report matches the location and everything to this well, then there's a possibility this well would not need to be drilled out. No. The problem is that I would have to review that plugin report and make sure that we're talking about the same location that's in this photo.
Very good. Let's now turn to the DeArmond lease.
Mr. Horst, if I could interject just briefly, looking at sort of the pace of things so far, I think we've had 2 exhibits so far out of, I don't know the exact number, 10 to 15. And I'm a little concerned if we devote maybe an hour to each one, we certainly don't have that amount of time to vote. So I'm not necessarily instructing you on how to do the examination at this time, but just to ask you to keep in mind that if you're planning to devote a similar amount of time to each exhibit, at a certain point, we're going to run out of time. And so just keep that in mind. And if there is a way to maybe get at what you need out of each exhibit in a more timely fashion, I would certainly encourage that. If there are certain exhibits you think we could talk to Mr. Marsh about just stipulating into the record for what they're worth, I would encourage something like that. So just a thought to keep the pace of things in mind.
Thank you, Commissioner French, and I am certainly sensitive to the fact that the only way to go through the compliance efforts that Quito Inc. has made is to either go through each of these exhibits on a well-by-well basis, or alternatively, if litigation counsel would agree, we would offer each and every one of these exhibits to demonstrate to the commission efforts made by Quito Inc. to achieve compliance with the statutes, rules, and regulations of the commission. And I would make that proffer.
Mr. Marsh, I'm sort of inclined to ask, I know you probably have not had time to run through each of these exhibits to see what each one is. I mean, I assume they are similar. They're probably letters with pictures attached. Well, one, let me ask you, have you had time to review them, and what would staff's position be on admitting them into the record to show efforts at compliance? Or would you like a moment to confer with your client to discuss whether you think there's a way to maybe get these into the record in a more streamlined fashion?
Commissioner French, if I may have a moment to confer with my client and see what.
Let's take a 10-minute. Well, let's take a 5-minute recess. I don't want to take up more time than we have to. Let's take a 5-minute recess until 10:45, and then we'll rejoin. If you need to then contact Mr. Horst and have a brief discussion, I'm acceptable to that as well, if it ends up saving us time in the examination period. So we are off the record. We're reconvening at 10:45.
Thank you.
Thank you.
All right, it's 10:45. We are back on the record in this proceeding. Do I have Mr. Marsh and Mr. Horst? It looks like we may not. Oh, Mr. Marsh, looks like you're back.
I'm back.
Mr. Horst, are you back?
I am back.
Okay. I think where I left it was Mr. Marsh. I was giving you a moment to confer with your client. Do you have any thoughts on a stipulation allowing documents into the record for whatever they purport to show?
I don't know that I have necessarily any objection to it. I think, they can show any progress that they wish to show, but the bottom line is whether or not they're in compliance with the rules and regulations, which I think ultimately they're not, and that staff will be able to do through redirect or cross-examination.
Well, that was going to be my question is would staff be willing to stipulate to admission of the documents into the record, realizing that you would have an opportunity to redirect on those documents?
Yes.
Mr. Horst, given that stipulation, do you believe that could speed up your laying your foundation and discussion of the exhibits with Mr. Dooling?
Yes, it would speed it up.
Okay, well, let us move forward then. And one more thing to keep in mind. Commissioner Duffy, I see you're raising your hand.
Thank you. As these documents all arrived very late, is there a summary that lists the leases with the operator's belief in his current status of each of the wells on those leases, similar to looking at Mr. Dooling's attachment, exhibit RD1, where it goes through? Is there a summary page that perhaps is available that would be helpful?
I don't know that staff has anything outside of.
I guess I'm directing this at Mr. Horst.
Okay, sorry.
Commissioner Duffy, there is not a summary page. However, Mr. McCann could testify as to the summary of the efforts that Keto Inc. has made to achieve full compliance with the statutes, rules, and regulations. And I think that testimony would more succinctly and timely address the issue.
Okay, and he is the last witness. So I would ask Mr. Marsh, is Mr. Dooling able to discuss each lease as to the status, the current status?
I believe so. Mr. Dooling was present during the December field inspection reports conducted by staff. So I think he would, correct me if I'm wrong, Ryan, but I think he would have a decent idea of the current status of operators' leases.
So just to share, so probably what I will be asking is to go through that exhibit RD2, all 9 pages, and ask what the most recent status is. Thank you. RD1 and RD2.
Thank you, Commissioner Duffy. With that, I think the one to-do item that I have is, I believe, Mr. Horst, you already have sort of proffered all of these exhibits, and I believe staff has found it acceptable to admit them into the record. Could you please just list off for the record each of the exhibits that you are asking to have admitted into the official record, so we have that?
Yes, certainly.
Go ahead.
So in addition to the record A and D 001 through 005, I believe it is. There's the Beaver 001 through 007. The Diamond marked DEAR 001 through DEAR 052. The DOTY DOTY 001 through DOTY 016. The Flossie White 001 through FLO 001 through FLO 012. The Graham lease GRA 001 through 011. The Inglefield lease ING 001 through 022. The church lease, also known as the LDS Church, that's Church 001 through 013. The M&M Kirchner lease, M&M KIR 001 through 011. The McCann lease, McCann 001 through 010. The McFarland DeLong lease, capital M, small c, capital F 001 through MCF 022. The Morton lease, MORT 001 through 011. The Mullen lease, MULLIN 001 through 003. The Sears lease, Sears 001 through 046. The Smith Lolly lease, SMLOL 001 through 010. The Solomon lease, capital S, small OL 001 through 034. The Tom Appleby lease, TOMAPP 001 through 011. the wall lease. Wall 001 through wall 023. The Williamson lease, WIL 001 through 009. And then documents identified as Quito Inc. General, QUI 001 through 004. And we would offer each of those exhibits into the record.
I didn't hear the Anderson. Was that part of the, of your listing?
It was Commissioner Duffy, again, Anderson. Is AND 001 through AND 005.
And Mr. Marsh, if you were able to follow along with each of those exhibits, any objection to admitting the exhibits into the official record?
No objection.
Okay. The reference list of exhibits, each will be admitted into the official record. Mr. Horst, I will turn back to you to continue your examination of Mr. Dooling, and hopefully that will speed us up.
It will, Commissioner France. Actually, Mr. Dooling, I only have a couple of other questions. Did you have a telephone conversation with Mark McCann on December 16, 2022?
Yes, sir.
And in that telephone conversation, did you discuss 2 TA applications that had been denied based on incorrect shut-in dates?
Yes, sir. That is correct.
Okay. The shut-in date is a date to be filled in on the temporary well abandonment application form. Is that correct?
That is correct.
Is the shut-in date defined by KAR 82-3111?
Yes, I mean, it is, it's the last day that the well was produced. I'm trying to find, hold on just a second. I'm not sure. I don't believe there's an actual definition of the word shut in the 82-3-111 regulation. No.
Is there a definition of shut-in the definitions section of the Kansas Administrative Regulations under Part 82 of the regulations governing oil and gas operations?
I would have to look at all of them. I'm not sure where that would be at, sir.
Well, let me suggest to you, just for purposes of this question, that there is no such definition there. Are you familiar with the Commission's website?
Yes, sir, I am.
Where forms including the temporary well abandonment application form are located?
Yeah, you're talking about on Kohler?
Yes.
Yes, sir, I'm
Yes.
familiar.
Or that's accessible on the internet. Do you know if there are any instructions associated with the temporary abandonment well application form?
I do not know if there's directions. I'd have to look that up. visit with operators filling them out every day, so that I don't know where that would be. I mean, I'd have to get online and look for that, sir.
So, Mr. Dooling, you've indicated that date of last production could be identified as a shut-in date. Is that correct?
That is correct.
Would an operator's well maintenance record also be useful information in terms of when operations were last conducted on a well?
If possibly, if they had that information.
So is it possible that, for example, on the Diarmid M1 well, the service work was performed on the well at a date that is not identifiable, let's say, by reference to production information? I didn't ask that very well. Would the operator's internal well service records be helpful in determining the shut-in date? I'll ask that.
Possibly, but in this instance, Mr. McCann stated that he had no information when the last time this well was produced or worked on. That's what he stated on, I believe it was, you said Friday the 16th, but we actually discussed that well on Thursday the 15th. We, I believe, discussed an Inglefield well on December the 16th, or vice versa. One of those, we talked both days on Thursday and Friday the 15th and 16th.
Okay. In your discussions with Mr. McCann, either on Thursday the 15th or Friday the 16th, did you indicate to Mr. McCann that the District 3 office would not be able to determine whether Keto Inc. was in compliance with the statutes, rules, and regulations on a well-by-well basis before the end of the year?
That was not a question, no.
That was not part of your discussion?
If we would know that there is completely in compliance by the end of the year?
If you
No.
were going to be able to determine whether Keto Inc. was in full compliance or what the compliance issues were, did you have any discussion about whether you were then able to determine what the status of Keto Inc.'s compliance was on the date of either the conversation of December 15 or December 16?
No, sir. We discussed a well on the Diarmid and a well on the Inglefield as far as the date shut in, what the appropriate date would be filled on the form. And that is what we discussed on those two wells.
Did you suggest to Mr. McCann that you were going to send an email to your supervisor recommending that Keto Inc. meet with District 3 staff to address the compliance issues?
That is incorrect. Mr. McCann stated that he would have a lot of wells that were like the Diarmid and Inglefield well that we discussed that has been shut in for several years. And at that time, he would not, there is no way that he could get all of those wells in compliance within 30 days. And he wanted to know if there was other ways of getting extended time. At that time, I told, and he asked about a compliance agreement. And at that time, I told him that there would be nothing due to a compliance agreement till after the hearing, and that he needed to email my supervisor, Troy Russell, and CC me if he wanted to discuss entering into a compliance agreement. I did not say anything about emailing my supervisor or saying that there would be a possibility. I did tell him there would be nothing happening until after the hearing today and possibly well past the first of the year. That's what was discussed.
Thank you. Commissioner French, I believe that concludes my questions of this witness.
Thank you. I appreciate that. At this time, I believe we'll turn toward commissioner questions. Commissioner Duffy, do you have any questions for Mr. Dooling?
Yes, and I note that it's just a few minutes after 11. What about, I'm trying to think best how to proceed here. So, Mr. Dooling, as part of your testimony, there's an exhibit of 24 pages, the RD1, and RD2, I believe it's 9 pages. So do you have that in front of you?
Yes, ma'am. My testimony RD1 and 2. Yes, I have those.
Okay. This is dated September 6th, and it appears, I mean, I'm going to have to ask you based on your knowledge, and I know you received some updates at the end of the week concerning status, right?
That is correct. There was a lot of information sent in the last week or so.
Okay. Can we just walk through these pages and to the best of your knowledge, where they have satisfied, the operator has, let's do it this way, where you're aware that they have satisfied the issues on that particular well, particular lease. If you just tell me what page you're on and you just walk through it where it's no longer an issue. The current status as you know it today.
Okay. Yes, ma'am. I will.
Can you do that? I mean, am I asking something that's really difficult for you, or I think that gives me an idea of the breadth and depth of this company's ability over the last, year and a half, how much they have satisfied in terms of violations.
Yes, ma'am. I will. I can do that. I have several notes on each well that you're referenced to in this exhibit. I don't know if you want me to.
Yeah, just fly through it. I'm just
Okay.
gonna make notes on my paper copy, and that would be great. And thank you, John, for bringing that up.
Do you want me just to start at the top and
Yep,
work down?
just start
Commissioner?
with Anderson 1 and just tell me your next page, and we'll do it that way.
Okay, I'll start on page 1, Anderson 1. My notes shows that the well is equipped for production. However, the flow line is running into a plastic tote with a crack at the bottom that could not hold fluids. So we still considered it inactive.
Okay,
And Anderson 3, we show totally equipped for production. Flow line running into a plastic tote. We called it inactive, considered it still inactive because there was no fuel in the gasoline powered motor that they inserted on the pump jack.
okay,
The Beaver number 1 had approved temporary abandonment form that was approved on 10/14. Records show that we need to revisit this and revoke it due to being shut in over 10 years.
okay,
Beaver 1A, we still have down as inactive as of December 6, 2022.
okay,
Beaver 3, we have totally equipped for production. Actually, no, the Beaver 3 was a TA was denied on December 15th, 2022. It was submitted by Quito for inaccurate shut-in date, and well information was not correct on the form.
Okay, so when you say Beaver 3, I
Yes,
see
ma'am.
we go to Beaver 1A and then we jump to Darnell 1A.
Okay, I believe I must have updated this sheet here
Okay,
due to the fact that they filed a temporary abandonment form.
okay, so I should add the Beaver 3. Okay,
As a denied TA inactive.
got it.
The Darnell, a temporary abandonment form was approved on 10/14 of 2022.
Okay,
The DeArmond 16, we have down totally equipped for production. However, all flow lines at the wellhead are shut in, but we classified it as capable of production.
okay,
17, we have capable of production.
great.
Do you want all the dates? That was 11/30. I'm sorry.
No,
Okay.
no, don't need dates.
Okay. DeArmond 25, we have approved TA.
Okay,
The DeArmond 30. Approved TA. 31, capable of production. DeArmond 32, we have capable, totally equipped for production. However, the flow line is leaking and will need repaired. Number 33, we have an approved TA that will need to be revisited due to incorrect shut-in date due to fluids U3C. 35 is the same way. It's approved. However, we need to revisit due to inaccurate shut-in dates on the form. The DeArmond 38 is an approved TA. Number 39, we have listed capable of production. The DeArmond 6, we have listed as inactive. The DeArmond M1 has a denied TA. DeArmond M12, we have totally equipped for production. However, all flow lines are shut in at the wellhead. DeArmond M3 there is an approved TA, but since the last field inspection, it needs to be revoked as the well is leaking its surface. So we would require a CIT needs to be performed on that well. The DeArmond M4 is capable of production. The valves are leaking and needs repaired. The DeArmond M5 is an approved TA. And I have a note that we need to revisit due to the inaccurate shut-in dates supplied. M8, capable and equipped for production. The flow lines were all shut in at the wellhead. The DeArmond OW2 and OW3 field staff did not re-inspect, as these wells are not on the operator's well inventory, but within a 1/4 mile AOR. So we did not go back to them because we knew the operator had not done anything with those wells. The Doty 1 has a denied TA twice. The Doty 2, TA was denied incomplete information. The Flossie White is not listed on the well inventory, it's still inactive. Floyd, the same with the Floyd casement 6 and 7. We did not go to those 2 wells as they're not listed on the operator's inventory. They fall within a 1/4 mile AOR of one of the operator's injection wells. The Graham 1A has a denied TA. The Graham 4 we have is fully equipped, capable of production. Graham 5, fully equipped, capable of production. The Graham 6, we have a denied TA. The Graham 40 -1, we have fully equipped, capable of production. Englefield 1A, fully equipped, capable of production. Englefield 19, fully equipped, capable of production. Englefield 23, fully equipped, capable of production. The Englefield 2A is still inactive, numerous denied temporary abandonment forms. I believe that one had been denied 3 times. Englefield OW1, OW3, OW4, OW5, OW6, OW7, and OW8. Staff did not revisit due to wells that were found within the 1/4 mile AOR. The Englefield CH24 has an approved TA with a note that we need to revisit that as the shut-in date supplied by operator is inaccurate. John Casement Nella 1A. Same way, it's approved TA, however, the shut-in date is inaccurate. We need to revisit that one. LDS Church 1 is still inactive. LDS Church 2 is actually producing. LDS Church 3 is an approved TA that will need to be revisited due to inaccurate shut-in dates. LDS Church 5 is the same way, approved TA that we found inaccurate shut-in dates. M&M Kirchner number 4 has had numerous denied TAs. It's still inactive without TAs. Mary G. Sears 3 TK has a denied TA. Mary G. Sears 4 has a denied TA. McCann 2A, that's one of them is still inaccurate. It's inactive, nothing. And the same way with the 3 is still inactive. Those 2 are the ones that Quito re-entered and haven't done anything with. McFarland DeLong number 11, we have listed as fully equipped, capable of production. McFarland DeLong 1 has a denied TA. McFarland DeLong number 2, totally equipped, capable of production. McFarland DeLong number 3 has a denied TA. McFarland DeLong number 6 has a denied TA. McFarland DeLong number 7 has an approved TA that will need to be revisited due to an inaccurate shut-in date. McFarland DeLong number 8, we have down totally equipped, capable of production. McFarland DeLong OW1, we did not go to bins. It is within a 1/4 mile AOR. McFarland DeLong number 5 is we have fully equipped, capable of production. The Morton 1, 16, and 18, we did not revisit due to the not on operator inventory within a quarter-mile AOR. Morton number 19, we have fully equipped, capable of production. Morton number 27, we have an approved TA that needs to be revoked because we need to have a CIT done as the casing was leaking from the field report in March. Number 3 for the Morton is hooked up, capable for injection. Morton number 5, we did not go to, same reason. Not on the inventory. Morton M1 is another one that the TA was approved. Further investigation shows we should revoke it due to being shut in over 10 years. Shut-in date was inaccurate. The Mullen OLCC number 2 was actually hooked up to be used as an enhanced recovery well. Mullen's number 3 has an approved TA. NJ Graham 2 and the Riley 47, we did not go to as they were not on the well inventory, but are within quarter-mile AORs of Quito's wells. Sears number 1 has a denied TA. The Sears number 10 has numerous denied TAs. It still has a denied TA inactive. Number 14, still inactive with the denied TA. Sears 22, we did not go to because of being not on the inventory within a quarter-mile AOR. Number 24, it was actually producing. Number 25, we did not revisit. Number 29, we did go back to this one, even though it wasn't on the inventory, but it is, this is one that he had sent in photographs saying that he got it back into production. So that's why we went to it, and that one was capable of production. Sears number 31 is still inactive. No TAs found. Sears number 32, we have listed as equipped, capable of production. 40 equipped, capable of production. Number 6, we did not revisit because not being on the inventory. Number 7, we have equipped, capable of production. Sears number 8, we did not revisit because of the same way, not on inventory. Sears number A2, we have several denied TAs. It's still inactive with the denied TA. Sears M2, we have equipped, capable of production. And then we'll start a list of Sears OW1 3A that we did not go to because of not on inventory within a quarter-mile AOR. Smith Lawley number 1 has an approved TA that needs to revisit because of shut-in date supplied is past 10 years. Smith Lawley number 2 is the same way. It's a TA that's approved, but we will need to revoke due to the shut-in date. Smith Lawley number 3. This well was equipped, capable of production. I have a note that during our last inspection, we also found a spill. Operator was notified to fix the spill and clean up. Operator is still yet to call the district office to report. Number 4, we have equipped, capable of production. Number 5, on the Smith Lawley, we have approved TA. Smith's Lawley number 6, equipped, capable of production. Number 8, we have as inactive with a denied TA. Solomon number 2, we have as inactive. Number 5, inactive. Solomon M1. We have equipped, capable production. With a note that the well having issues, I would have to refer back to the field report done in December. Tom Appleby, number 5. TA is approved. Tom Appleby, number 6. TA is denied. Tom Appleby, number 8. We have equipped, capable of production. Wall number 1. I have nothing on that to report. It must have been a well that we missed going to in our last inspection, trying to get to all these. We must have missed that one. 1B. We did not go to because it was within a quarter-mile AOR, not on operator's list. 2A, we have equipped, capable of production. 4A, equipped, capable of production. 5A, equipped, capable of production. 6A has an approved TA. OW1 we did not go to, not on inventory's license, well as not within a quarter-mile AOR. Williamson, number 1. We have equipped, capable of production. Williamson, number 3. TA was approved. Williamson, number 4. We have equipped, capable of production. Those reason we list them as capable of production, Commissioner, is we found four wells out of all the leases we went to that were actually producing when we was there. And we did not have time to have Guido come out and try to turn the wells on. So we went ahead and gave them benefit of the doubt of putting them equipped, capable of production.
Okay, very good. So, for example, on the wall OW1, the well within a quarter-mile area of review. So tell me why that is so significant. There were a number of these. So if you could please explain the significance of that.
Yes. Do you want me to go back and find the field report, or just as a significance of all the ones that we found?
Of all the ones you have found.
Okay.
Generally.
A lot of wells in these areas are old style alternate one shot holes. Wells that we were asked to do these lease inspections due to an order docket by the commissioners. So we went out and tried to locate every well on the lease. These wells on their well inventory, we also found wells not on their well inventory, but on the lease within a quarter-mile of active injection wells. So those wells were documented to show that not necessarily that Guido is responsible for those wells that are not on their inventory. However, the wells that affecting them with the injection wells that are permitted, we need to the possibility of pollutant fresh and usable water is there. So we need to probably revoke the EOR that's within that quarter-mile until that well comes back into compliance, probably plugged by either fee fund or operator, depending on if he wants to bring it into compliance so he can continue to use his permitted EOR, or it could be done by the state, but we don't know what time we could have the well plugged.
Okay, in District 3, is this unusual, Ryan, to find this situation?
Whenever operators file for EOR disposal well, they're supposed to list any well that is abandoned or not on their lease within a quarter-mile of the proposed site. there is a tendency to sometimes over the years, wells go out of compliance or found that are within that quarter mile that they might not have known about. At that time, most operators, we work to try to get something resolved with that well because most operators want to continue to use the EOR well. So yes, from time to time, we do find wells that are abandoned within an AOR. So it's not uncommon. It's uncommon probably to find this many within so many EORs.
So how long has the operator owned these leases where we find this issue of the quarter mile? And well, so is this a new problem?
Are you
for this
talking-
operator? Did he just
I'm sorry?
acquire, did the operator just acquire these leases and just discover this?
No, ma'am.
Okay. Let me ask you, have there been significant conversations between you and the operator of how to resolve this current issue regarding the AOR?
No, ma'am. We haven't had many discussions until last Thursday and Friday was the majority of our discussions. He had contacted us about a week prior to that about trying to haul water to certain wells and put down certain wells to show that they were being used. But that was the only other conversations I've had with Mr. McCann since probably the date that was in them March field reports whenever I contacted him about the McCann 2A and the McCann 3.
Okay. There was some information about the ability of the operator to access, is it both the Kohler and the RBDMS?
As far as the operator being able to,
Can the operator access it and input, or can the operator access to do a visual review?
of the AORs,
Yes, of the AORs or any activity related to of any of his leases and wells.
I don't
The op-
believe he has any
Go ahead.
access to RBDMS. He would have access to Kohler. I don't believe he can do any work on Kohler because his license has not. I mean, he has to submit everything paper wise right now.
Okay, so he submits it paper through snail mail or through email?
Now, he's everything we received at the district office has come through the mail.
Through
I haven't
the
received
snail
anything
mail,
through
through the
email.
US Postal
Yes.
Service. Okay, so you get it,
Yes.
and then what's the process? Do you scan it in or does central office scan it in?
It depends. He sends the TA applications to our district office, and our secretaries will scan it. And then we will also send a copy electronically to Wichita to be scanned and put in RBDMS. We don't put anything in RBDMS at the district office. The central office does that.
Okay, and then is the operator able to go out and see that the documents submitted by US Postal Service were actually applied to their particular lease information?
I assume on Kohler they can. They don't have access to RBDMS. No.
So through Kohler, after submission and scanned information, then the operator should have access to see what has been entered in, correct? And updated.
I believe so. Yes.
Have you, let's put it this way, how long have you been receiving through the US Postal Service information from the operator?
I
Approximately.
believe we received some stuff, some TA applications they weren't filled out at all. I think in September. I'd have to look back to see that date was the first time that we received TA applications. And then they weren't again, we did not receive anything until, again, I believe it was December the 9th.
Okay,
The first, I believe the first round was submitted to us in September.
okay,
Because I denied them on 9/8, all 20. And don't hold me to it, I have to read it in my testimony, but I think there was 28 that was submitted, I believe September 7th.
okay. So, thank you. When you discuss that a TA was submitted, but the shut-in date is incorrect, what does the operator need to do to, I mean, how is it that the shut-in date is wrong?
The ones that the district staff knows for sure, a lot of these EOR wells that Quito submitted put shut-in dates. You know, I'd have to pull each one, but I went back and reviewed U3Cs that the operator fills out for yearly for the UIC department. And there's been no water put down those wells for over 10 years. That was reported by the operator. However, when he filled out the TA, those dates were not reported accurately. And that was one thing that was missed when they were approved. And they shouldn't have been, because the well hasn't had any use for over 10 years. So the EOR wells, the ones that I said need to be revoked, they have not been used for over 10 years. So he would have to file for an exception to the 10-year rule, or plug or begin operations injected.
Okay. All right. So let me ask you, Ryan, in your opinion, is Quito presently in compliance with commission regulations, completely in compliance with commission regulations?
No, ma'am.
Thank you. Thank you, Commissioner French.
Thanks. Good morning, Ryan. I'm not gonna have a lot of real granular questions for you. I have to admit my head's spinning just a little bit, hearing a listing and of all the wells and sort of the compliance status. And I do appreciate, appears to be a good faith effort for you to try to track where we are on each well. I think that's important. I'm just going to give you my general impression and of what I've heard here. It seems we have a large number of wells for this operator that seem to be either on the cusp of compliance or going in and out of compliance. And it seems like that has become a problem in this case, because we're trying to determine at any one point in time whether all of their operations are in compliance. And it just strikes me that having so many wells in that state makes that a very difficult challenge at any point in time. Is that how it feels to staff, or would you characterize it differently?
No, I wouldn't characterize it differently. Operator has, since March, we found, a great deal of violations, and operator has tried to, I don't know the correct term, appears to try to wind address a lot of wells to make them appear capable of production. So he did not have to file a temporary abandonment form. Those wells are equipped. Part of those wells are totally equipped. I mean, it's very infeasible to have plastic totes sitting around to try to capture produced fluids without any transmission lines to or tank batteries. But when we call them capable of production, if you look at the field reports from March to the field reports today, the wells that we consider capable of production, all the jacks are, not all the jacks, but most of the jacks are in the same position. So if they have produced, they haven't produced very much.
Do you all ever look at KGS records or other records to determine if there's been actual production in the last year?
We do, and there's a lot of interesting information on KGS records. You know, it lists how many wells on the lease that on the oil that they sold for the year, how many wells produce that oil. And there's a lot of leases that, just for instance, maybe show 3 wells and have 10 wells out there. And it's those 3 wells that's produced the oil for the last 10, 20 years. So now he's, you know, operators saying they're capable of production, but realistically, they probably have not produced for several years. And when I say several, I'm talking more than 10, but going back in the 90s.
So if you were to dig deeper on some specific wells, we may find that we need that probably there has not been production and we need a TA application. Is that what you're saying?
There's definitely probably should have been more TAs filed than what's been filed, but realistically, the TAs would not be approved because they've been inactive for over 10 years.
Would you say, I mean, just the level of, you know, once you've done this review and the level of inactive wells and the compliance status of all these wells, is this, I guess, well, is this indicative? Is this just something that's happened in the last year? Is this indicative of sort of staff's knowledge of the ongoing operations of this operator? Is this in line with other operators in the area? I'm just trying to lean on your experience to understand what I'm looking at.
As far as the inactive wells, I'm sorry, my bandwidth, it broke up and I did not hear the question completely without breaking up. So
it was probably me. Just your review of the number of wells that appear to be inactive or in and out of compliance. Is this indicative of the ongoing operations of this operator? Is it typical of all the operators in your area? What's your opinion of that?
Indicative of this operator, yes. Other operators, we have other operators that have inactive wells, but most of the other operators are forthcoming, know that they have wells that have started to become inactive, getting close to the 10-year, even though they're filing the TAs. A lot of these wells, obviously, there wasn't no forthcoming till after we did our lease inspections that was ordered by the commission to go do. Mr. McCann's been in the business for a lot of years. And the dates of these wells change a lot from from what I've seen in the past on applications. You know, a lot of the ones you've just submitted, say a shut-in date of July or August of 2022. Well, we know for sure that that's not accurate, but it's just a way to try to get more time of filing TAs instead of actually doing something with the well. So yes, the answer to your question is it's this, for this operator, it is a problem that's been several years.
Okay. Thank you. I don't think I have anything more. Commissioner Duffy, go ahead.
Yeah, real quick, can you describe that plastic tote? I know in my head what I'm thinking is a plastic tote. I buy over at Walmart, putting stuff to throw down in the basement, got the Christmas decorations out, whatever. So what is a plastic tote here?
No, ma'am, it's not something you would buy at Walmart. It's, most of them have, from a farming side of it, have herbicides, stuff like that. That's what they're used for when they're new. It's a tote that will approximately hold less than 300 gallons. I believe most of the ones that I've seen on those leases, you know, I would hold somewhere around 275, 300 gallons, well less than 8 barrels, probably 6 to 7 barrels of total fluids. That's not just, I mean, that's the total fluids of a wellbore coming
Okay,
out.
thank you, because so similar to what a farmer would be getting to spray the fields, the herbicide comes in and attach it to the sprayer and go out on the field.
That is correct, yes.
Okay. Second question has to, well, actually, it just vanished from my mind. I should have written it down. Let me think here a second. Okay, well, I'll ask it to somebody else that comes up. So thank you. Just wanted that clarified. Oh, I know.
Yes, ma'am.
I did. So in the picture that you all submit as to whether a pump jack is working, you show it up and then a second picture will show it down from the same vantage point. So I noticed on these that it just showed one picture with a pump jack. I mean, wouldn't you really know whether a pump jack is working with the submission of two pictures?
The only way you can take two pictures, Commissioner, is if the well was actually in producing during the lease inspection. All these wells that are photos in our inspection reports were inactive. Like in our March field reports, we actually classified some wells as producing because they were capable of production, but we did not see the wells going up and down.
Okay.
So the only way to get two photos if the well is actually in production. However, I can say when we did back to all the leases in December, we noted 4 wells out of every location, every lease that we went to that we actually seen producing at the time of the inspections.
Okay. All right. Thank you. Again, thank you, Commissioner French.
Yeah. All right. Well, I think that concludes commissioner questions. Mr. Marsh, do you have any redirect for Mr. Dooling?
Yes, if I may. Okay, Mr. Dooling, I know one of the things that Mr. Horst hit on from the very get-go was 823403 and the inactive wells within the quarter-mile AOR of Keto's injection wells. I guess the first question I have is, are abandoned wells presumed to be an environmental threat?
Yes.
And why is that?
We do not know the construction and completion of all the wells that are abandoned. They're all presumed a possible threat to fresh and usable water, because you can have contamination, you know, not just downhole, but also from uphole.
And so whenever you talk about well construction, so there could be issues in the well itself that may not be visible at surface.
Absolutely.
Okay. I know the next thing that Mr. Horst talked about was the ACO1 submitted for the McCann lease. And so pulled up what he marked as McCann 002. Can you see that form?
Yes,
Okay, and when are ACO ones supposed to be submitted in relation to when a well is drilled?
within 60 days.
Okay, and the date on the spud date for this well was November 15th, 2021, correct?
Kelsey, can
That's-
you zoom in
yeah.
just a bit?
Sure.
Yes, that's what it says, 11/15 of 2021.
And what was the date of submission for this form?
10/31 of 2022.
So the
Almost
form
a year.
was submitted close to a year after the well was drilled.
That is correct.
And this was a well that Keto did not make a spud call to district staff on, correct?
That is correct.
And then looking at exhibit McCann 004, what was the spud date for that well? McCann 2A.
11/18 of 2021. It said, I guess it looks like the completion date was 11/22 of 2021.
And what was the date that this document was submitted?
9/19 of 2022.
So once again, we're well past the date to submit ACO ones, correct?
That is correct. And I think I misspoke. I said 60. It should have been 120 days on an ACO one, I believe.
Okay, thank you. And on that second well, Keto did not make a spud call into district staff, correct?
No, they did not notify the district office on either well, and only actually filed an intent on one of them.
Okay. Now I know Keto submitted numerous exhibits about wells that they allege have been addressed by Keto. Many of those wells talk about wells that have been returned to service. Did Keto, in the attachments they provided, take pictures of wells in the upstroke and downstroke positions?
No, sir. They supplied us one picture with of each well, and some of the pictures they just took the back picture of the back, the back of the well. You couldn't see we tried to, when we take photos, we try to show the actual well, pump jack, everything. But no, the answer to your question is no, it's just a one photo. There's none numerous that shows up and down positions.
So, and I know Commissioner Duffy talked about this a little bit earlier, but so basically Keto hasn't really provided any documentation showing that the wells have actually gone up and down. Would that be right?
That is correct.
And I think you mentioned it earlier, but did you also say or talk about the position of these pump jacks in relation to their position back in March?
Yes, if you look through the photos of the lease inspections in March and look at the photos that were supplied by Quito, and also look at the photos that we in our lease inspections from November 30th through December, I think it was 5th or 6th when we concluded, you will find that a majority of those wells, the pump jacks are in the same position on each of those photos. The ones that have moved a little bit, it appears on some of them where the bridle cable was not hooked up, they actually had to rotate it down to hook the bridle cable on. But if you look at the polished rods, it's the same dimension from the wellhead up. So, I mean, there's not a lot of documentation that shows that the wells actually produced.
And I know you mentioned the polish rods. Were the polish rods, still dull, or did they appear that they had actually gone up and down recently?
One that really stuck out in mine, and I believe it was on the dearmament. It was a new polished rod. And it didn't even have any marks where it goes through the stuffing box rubbers to, show that it had went up and down. Anytime that you go through stuffing box rubbers that's got grease or oil, there should be something residue on the polished rod. That's the only one that stands out on my mind. But a lot of the polished rods were all pretty dull, where you could see there was no movement for quite some time to really polish those rods.
Now, I know you mentioned earlier, you inspected these leases at the last day of November through early December, correct?
Yes, I was with staff. I was with Dallas and Thad on different leases, but I went to all leases with them in December, end of November, December.
And what wells were you inspecting during those lease inspections?
We tried to go to all the wells that were listed that were out of compliance in the March field reports. We did not go to each individual well on the lease. We just tried to go to the wells that were originally deemed out of compliance from the March field inspections.
And during your December inspections, did you still find wells that were out of compliance with the commission's rules and regulations?
Yes.
Did you find additional violations that were not previously there back in March?
We did. We found some ongoing spills. And I had Thad, since he worked that area, contact Mark to let him know about the spills. I believe there was one on the Smith Lawley, one on the McFarland DeLong, and one on the Williamson that was a discharge at the tank battery. And Thad has contacted Mr. McCann to let him know and to notify him it needed to be reported to a district office. And to this date, Quito has not reported any spills to our district office.
Okay. I know one of the leases that we talked about in particular, and it's been referenced maybe a little bit already, is the Anderson lease. I want to show the first page. Is this an updated version of the Anderson lease from November 30th, 2022?
Yes.
Were you involved in the creation of this report?
Yes.
Okay. One thing I wanted to discuss was, I know you mentioned a crack in the storage tank that Keto had on site. Is this the crack in that storage tank that you mentioned?
Yes, sir.
And was there any evidence of a spill coming from that storage tank?
Yes, that right underneath of that trailer was oily, that led to the area that we stepped back and took a picture. I believe that spill was there previously from the wellhead, and then what little fluids did come out of that well into the tank escaped out of the tank back on it. It had it's kind of hard to show in that picture, but it did have a fresh oily show on the dead area there.
And Keto never called in this spill, correct?
No, Quito has not called any of the spills that we found recently in.
Has Keto done anything to remediate this spill?
Not that I'm aware of. I've had no information from our secretary stating that they had called it in and done any remediation to it.
Now, I know Commissioner Duffy had some questions about the plastic tote. Is this a picture of what those plastic totes look like?
Yes, that is the most of the everywhere. That's the style that was there. The one that you showed previously is the only one that was on a trailer. The rest of them are those type of plastic totes there.
And you mentioned that these are mainly used for or utilized for farming practices. Is that correct?
Farming and ranching, yes.
So not typically used for oil and gas industry purposes?
No, sir. No, this is very, very unusual.
Did you also receive? Well, I'm asking questions, see if I can find it. So you stated you received different documentation from Keto regarding compliance, or ways that they've tried to complete compliance at their leases. Is that right?
Yes, that is correct.
Did you receive such papers for the Solomon lease?
Did I receive paperwork from the Solomon? I believe so. Let me.
I guess
No,
while he's doing that, sorry, I was going to ask that the commission take administrative notice of exhibit KCC staff 1A.
Mr. Marsh, can you pull that up again real quick?
Sure. That way I don't get too far ahead of myself. It's staff's December report for the Anderson lease.
Okay. Any objection by Mr. Horst?
No objection, but would note for the record that this is a report that was provided to Keto on the morning of today's hearing, and we haven't had an opportunity to review it.
Okay. Well, I am going to accept it into the official record. We've been pretty liberal, again, trying to recognize what is in compliance and out of compliance, and have taken additional information from both parties. So we will take notice of this record.
Okay, thank you. So to go back to my question before I backtracked a little bit, Mr. Dilling, did you receive documentation from Keto regarding the Solomon lease?
I'm looking real quick, Kelsey. I'm sorry. I should have had that in order.
Well, I know there's a lot of them. I'm jumping around.
I
on
did.
this, so.
We did not receive any TA applications, but we did receive some documentations on, I believe it was December 13th is when our district office received it for the Solomon M1. We received a letter from Mr. McCann. We received it on December 13th. The Solomon 60, we received a letter on December the 9th. The Solomon 61, we received a letter on December the 9th. And I believe that's the 3 letters that we received with photos trying to document production or injection.
Okay, and had Keto filed temporary abandonment applications for the Solomon 6, 60, and 61 prior to this December 9th through the 13th letters?
I believe they did, and I believe they were denied because it had been 10 years. It wasn't on our original violations that Commissioner Duffy asked to go through, because at the time of first inspection, I believe there was an approved TA on them. And then when they refiled TAs, they were denied. Here in 2022, they were denied because they'd been out of use for over 10 years.
And so in these letters, Keto's stating that they're introducing water into these wells. Would that be correct?
That's what they're claiming, yes.
And can you describe what you see in this picture?
Yeah, well, it appears to me that's the wellhead for the Solomon number 6 that you see, and there's a hose with water squirting out of it onto the ground.
And did Keto report this spill?
No.
Is there anything else with the valves or anything like that that would make you second guess whether this well has actually been returned to service?
Well, that's the what you just pointed to is where the flow line, actually that valve shut off there, but there's not being water put down the well at that point in time because it's going out on the ground.
Maybe I was a little bit presumptuous, but I mean, would staff consider taking a few barrels from a plastic tote and putting it down a well as returning a well to service?
No, these are all EOR wells, enhanced oil recovery wells. You most of the time you have enhanced oil recovery wells to help produce oil to producing wells. It's considered a flood. That tote 275 to 300 gallons, so somewhere between 6 and 7 barrels. That looks like a 2-inch well sticking up at probably the depth. There's probably not even enough fluid in that plastic tote to fill the 2-inch, more or less, actually inject. The only reason I can see that they would even do this, there must not be a from the tank batteries injection pump to the well. They must not have established production with water to be able to inject. So this is not a form of putting the well back into service.
And are there similar pictures at the Solomon 60 and 61 wells of water running onto the ground?
Yes.
And did Keto report either of those spills?
No.
Okay, thank you. I don't believe I have any other further questions.
All right. Mr. Horst, we're running right up on lunchtime. Let me just ask you if you have any final recross for Mr. Dooling.
Just a couple of very brief questions, I think.
I think if you could keep it fairly brief, let's try to squeeze that in before we go to lunch. Go
Mr.
ahead.
Dooling, thank you. Mr. Dooling, on the photographs that Keto submitted with its letters on equipped wells, did District 3 advise Keto that it needed to provide more photos showing the wells in the up and down position?
No.
Actually, I don't think I have any other questions at the present time. Thanks.
Thank you, Mr. Horst. Well, at this time, we will break. We will go off the record. So we are now off the record. We're going to break for lunch. If the parties are amenable, I'd like to keep it a short lunch, 30 minutes, if that's possible. And we would let's actually do 35. We'll return at 12:45. And we now stand in recess. Thank you.
Okay. Yes. So, yeah. We have limited lunch opportunities.
John.
Yeah.
I sat there listening to all those things that Julie said.
Uh-huh.
Mr. Horace,
Oh, I thought I was muted. I'm sorry.
you are not muted.
Pardon me. Okay.
All right, I show 12:45 here on my clock. Do we have everyone back from lunch? See Mr. Marsh. Mr. Horst, are you back? Can you hear us?
Can you hear me?
Yes, we can. Very good. Well, we are now back on the record in this proceeding. And one bit of housekeeping, I realized I forgot to dismiss Mr. Dooling from the witness stand. So Mr. Dooling is dismissed and released. And at this time, Mr. Marsh, I believe we are ready for you to call your next witness.
All right. Thank you, Commissioner French. Staff calls Dallas Logan to the stand.
Mr. Logan, will you please raise your right hand for me? Do you swear or affirm the testimony you are to give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Marsh, the witness is yours.
Thank you. Can you please state your full name for the record?
Dallas Logan,
And Mr. Logan, by whom and in what capacity are you employed?
the Kansas Corporation Commission as an environmental compliance and regulatory specialist.
And what is your work address?
137 East 21st Street, Chanute, Kansas, 66720.
Are you the same Dallas Logan who caused to be filed in this docket testimony consisting of 11 pages on September 7th, 2022?
Yes,
Was this testimony created by you or at your direction?
yes,
Now that you're under oath, do you have any corrections to make to your testimony?
no,
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
yes,
At this time, staff moves for the admission of Mr. Dallas Logan's pre-filed testimony filed on September 7th, 2022 into the formal record.
No objection.
On motion and hearing no objection, the commission does admit the described testimony into the official record.
Thank you. At this time, staff tenders the witness for cross-examination.
Mr. Horst.
I don't believe that the operator has any questions of Mr. Logan.
Okay, thank you. We will now move to commissioner questions. Commissioner Duffy, do you have any questions for Mr. Logan?
Yes, thank you. Good afternoon, Dallas.
good afternoon.
Just real quick, I noticed that in your testimony, you were out inspecting wells March 23rd. Have you been out recently to these aforementioned wells in your testimony?
Yes, I was out with Compliance Officer Ryan Dooling on December 30th, November 30th, December 1st, and December 5th. And I also helped our compliance officer with not only the leases that I had previously done in March, but the ones that Rodney Breeze, who had worked with the commission or for the commission in March, that he'd also done. I helped go back through those leases also.
Okay, so you're familiar with the leases, is that correct?
Yes,
From your visit in March to your last visit here at the end of November, 1st of December, in the leases that you identify in your testimony, did you see that the operator's issues had been resolved and that the operator is now in compliance on all the leases that you mentioned in your September 7th testimony?
no, operator is not in compliance with all of the commission's rules and regulations on leases that I perform lease inspections and follow-up inspections on.
Okay,
They're still out of compliance.
thank you. I appreciate that. That's all I had, Commissioner French.
Thank you. I don't believe I have any questions, and I'm not sure there was much there. Mr. Marsh, let me just make sure you don't have any redirect.
No redirect.
Very well. All right, Mr. Logan, I believe we have reached the end of your testimony. That was nice and brief. You may step down virtually and you're released. Mr. Marsh, you may call your last witness.
Thank you. Staff will call Thad Triboulet to the stand. If I may go get him or make sure you set up.
Go ahead, take whatever time you need.
All right, thank you.
Good afternoon, Mr. Triboulet. If you can please raise your right hand for me, and you'll need to go off mute as well. Please raise your right hand. Do you swear or affirm the testimony you are about to give in this proceeding today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Marsh, the witness is yours.
Thank you. Can you please state your full name for the record?
Thad Triboulet.
And Mr. Triboulet, by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission, Conservation Division. I am an ECRS officer, Environmental Compliance Regulatory Specialist.
Mr. Triboulet, what is your work address?
My work address is 137 East 21st, Chinook, Kansas, 66720.
And are you the same Thad Triboulet who caused to be filed in this docket testimony consisting of 11 pages on September 7th, 2022?
Yes,
Was this testimony created by you or at your direction?
yes.
Now that you're under oath, do you have any corrections to make to your testimony?
No, I do not.
Do you swear the answers contained in your pre-file testimony are true to the best of your knowledge?
Yes,
Thank you. At this time, staff moves for the admission of Mr. Thad Triboulet's pre-filed testimony filed on September 7th, 2022 into the formal record.
No objection.
My apologies. Hearing no objection, the reference testimony and exhibits will be admitted into the official record.
Thank you. At this time, staff tenders the witness for cross-examination.
Thank you, Mr. Horst.
Good afternoon, Mr. Triboulet.
good afternoon.
Mr. Triboulet, have you had contact with Mark W. McCann on the Sears lease, among other leases that you have inspected?
As far as you're saying as the Sears, I did not do the field investigation on the Sears.
Have you previously inspected one of the wells on the Sears lease that was returned to operation by producing into a tote or test tank?
Yes, that would have been like 6-8 months ago. I couldn't tell you exact date on that.
I may be mistaken, but if I recall correctly, I believe that was the Sears KCHA number 23 well.
That sounds correct.
Okay. And did you go to the Sears lease to verify that that well was fully equipped and capable of operation?
Yes,
And did you observe that well pumping?
that's been multiple months ago. I would have to look back on that for sure.
So you do not recall today if you observed the well pumping?
Well, there was 2 instances there. Mr. McCann was actually trying to produce fluids with nitrogen to come out of that well. And And then that we decided that's not going to be, that wouldn't be count as in production. It'd be considered still inactive. And I honestly couldn't tell you. I think when I went back the second investigation on that Sears 23, I think it was in production then, maybe.
Do you today have an independent recollection of what the receptacle was that the fluids were being produced into?
Well, the first inspection,
I can't hear Mr. Triboulet.
there we go.
He's on mute.
Can you hear
There
me
we go.
now?
Yeah, now we can.
Okay. Basically, on the first investigation, he was trying to turn it back into production. He was using a tote. And then we declined that. That was declined. And then the second, and like I say, this has been months ago, and I'm pretty sure that it was hooked into a lead line that day.
Do you think your recollection would be superior to that of Mr. McCann's as to whether it was hooked into a lead line or producing into a tote?
Like I say, the first time I was there, it was producing in a tote. The second time, I think it was producing into a lead line. But like I say, that was way back when, been several months, 6 months ago or more.
One of the leases you inspected was the Beaver number sign 2, or excuse me, the Beaver lease. Is that correct?
That is correct.
Okay. And in your report dated March 15, 2022, among other actions recommendations, you also recommended that the KL Beaver number 2 be drilled to table 1 and replugged, as this well has cement at surface but is listed as producing on operator well inventory. You recall that?
I do recall that.
At the time of your inspection, what was the condition of the well at the surface?
There was cement at the surface of the well. It's 4.5 casing with cement to the surface. And if I recall, that well was showed as producing on his inventory. And there was no, so there, as far as I know, that was on his well inventory. That well was shown as PR producing, and this well had cement to surface.
Was there any physical evidence that that well had been drilled out?
Had been drilled out? No.
Yes. Okay. And were you aware that a plugging record has subsequently been supplied to the commission for the KL Beaver number 2 well?
Yes.
Have you had an opportunity to inspect that plugging record?
No, I'd be glad to look at it, please, if we could bring that up.
So, Mr. Myers, if we could bring up document BEV005.
Yes, one moment. Mr. Horsted is there.
Yes. Yes. So, Mr. AAA, have you take a moment to review this plugging record, please?
Can you scroll down, please? Okay, we can scroll back up, please. As you can see on up, please. We have an API number that is not the correct API number that is on the, says API number in the top right-hand corner of the page. It says 10-3175 and the lease name is the LK Bever. Well number, I guess that's well number 2. I'm not sure if that's a question mark or a 2. I'm not sure if this is the right plugin report. Since
So
there's not an API number on that I see on this.
So Mr. AAA, whoever filled out this plugging report back in, looks like 1986 for Liberty Hill Oil Company failed to identify the correct API number at the top right-hand corner of the form.
Yes, I would say so.
Have you had an opportunity to try to match the footage locations against the GPS location of the KL Beaver number sign 2 well?
No, I haven't.
If the footage locations match, would you have any reason to doubt the accuracy in the information other than the API number?
Well, we'd have to see how close they were. And then again, you know, there was no call in. There's no CP23 record to be found. So, you know, it's hard to go off exactly how close the footages would be. So.
All right. Did you have an opportunity to inspect some or all of the leases operated by Keto Inc. recently?
I inspected, Ryan Dooling and I inspected range 11. All leases in range 11.
So can you identify which leases that you inspected in range 11?
I inspected the Bever, the Doty, the Flossie White, the LDS Church, the M&M Kirchner, McFarland DeLong, the Mullen, Smith Lawley, Tom Appleby, and the Walleys in Chautauqua County, all in range 11 east.
Are you aware that prior to today's hearing, Keto Inc. has submitted a number of TAA applications on the leases that you recently inspected?
I don't know how recent you're talking, but you're saying that he has filed some TAs. Is that what you're saying? Is that
Yes.
what you're?
Are you aware that Keto Inc. has filed some TA applications on some of these leases?
Yeah, I mean, yes.
And some of those applications have been approved and some have been denied.
Yes.
Some have been denied based on lack of surface control.
Okay. Yes.
Well, is that correct?
Yes, I would say that.
And the reason for surface control is what, Mr. AAA?
The reason for surface control is for any type of fluids that may come up. You got to have an approved CP111 on a well that is open to the environment that may produce some type of fluids to the top. and have an environmental concern. That's why they need to be shut in with a swedge valve.
So in other words, that is to confine the fluids in the well and prohibit escape of the fluids onto the surface.
Yeah, that's correct.
And are you then aware that Quito Inc. has resubmitted TA applications, Form CP-111, with photographic evidence showing that well control has been established at those on those wells and at those locations that were initially denied?
Yes, I mean, if you need to bring them up, we can bring them up. I mean, if you have the information available, we'd have to look at each one of them. But yeah, I understand what you're asking. And yes, there's some that's been put back in that has surface control and has an approved CP-111.
Okay. So, Mr. AAA, would you agree that Quito Inc. has made a good faith effort to try to complete and properly file temporary abandonment applications on the wells and the various leases that it operates prior to today's hearing date?
No, I would say not. There hasn't been enough CP-111s filed, and there hasn't been enough approved CP-111s that have been filed. There's still a lot of wells that are out of compliance.
And following your recent inspections, did you contact Mark McCann to advise him of any compliance issues that remain?
No, I did not contact any type of compliance issues while doing the field investigations in Range 11 East.
To your knowledge, did any other employee of the District 3 office contact Mr. McCann or his office to advise of any continuing compliance issues that remain prior to today's hearing date?
I am not sure if any other staff has contacted. I know that there's been tremendous amount of paperwork that's been mailed. He's been well aware of which wells that are inactive and need, which wells that have compliance issues.
Is it fair to say that Quito Inc. has made substantial effort to try to complete the necessary paperwork on the various wells that it at least identifies as wells that need to be temporarily abandoned?
I would say no, not enough CP-111s have been filed because there's either surface control problems or more compliance issues. A lot of them wells, there's a lot of them wells that are not, that do have surface control, but they've been out of production since 1995. They are not going to be approved for a CP-111. As far as Mr. McCann making adjustments and trying to satisfy the KCC needs, I would say no to that answer.
Mr. AAA, how have you been able to determine that wells have been out of production since 1995?
You can go on KGS, and KGS has all the oil production for every lease, for every operator. So if you can go back to, say, the Doty lease, you can go back and you can track each year how much oil production has been produced each year from that operator. And there is multiple leases that Mr. McCann has that has not produced any type of oil going back to the early 90s.
beyond the production records, is there any other method that you've employed to attempt to determine when wells were last produced?
There are some UIC wells that you can go back to, and it's called a U3C report, which the operator has to report how many barrels a month that year that was reported down into that injection, how much barrels of water they reported. And from my knowledge, from the ones I've seen in range 11, the ones that I investigated, there were no reports of any type amount. There was no report of any total amount of barrels for that U3C.
Mr. AAA, on the leases that you recently inspected, did you observe wells that had been re-equipped where on prior inspections, the wells lacked some part of equipment, such as a motor or a bridle?
That is correct.
And are you aware that Keto Inc. has submitted letters and photographs depicting the wells that at least it contends have been operated and would therefore a return to operation would therefore not be subject to the provisions of KAR 82-3-111?
I would have to look at the pictures, Mr. Horst.
But just as a general proposition, you're not aware of any such wells that?
Yeah, there has been some wells put back in. He has made some type of effort to put these wells capable of production. Now, you got to remember that out of all the wells, we only seen a total of 4 producing out of all the wells. Some are considered capable of production. As what we consider capable of production is you flip the electric on, or you have to pour gas in the motor and start the motor, and it runs efficiently.
I may be paraphrasing Mr. Dooling's testimony a little bit, but in substance, my recollection of his testimony was that District 3 staff did not have sufficient time to contact Mr. McCann and make arrangements for him to accompany District 3 staff on its recent inspections of the leases. Is that correct?
That's correct.
So during any of these inspections, no representative of the operator was present to demonstrate whether or not a well that Keto Inc. contends is fully equipped and capable of production is actually capable of going up and down.
Right. Right.
And do you believe that verification of the ability of any of the fully equipped wells to pump and produce fluids could be accomplished by the parties jointly going to the wells at issue and verifying whether they will or will not operate?
Yes, the operator would have to be able to engage the well and put it in production status. I would have to see it running in production status.
And as a general proposition, that is a matter that is not known to you today.
Do repeat that?
In other words, since you haven't had an opportunity to see it actually physically operate, any of the equipped wells actually physically operate, you do not know whether or not they are fully
Capable.
equipped and capable of operation.
Correct.
Okay, all right. I think that's all the questions I have, Mr. Tribole. Thank you.
Thank you.
All right, at this time, we will move to commissioner questions. Commissioner Duffy, do you have any questions?
I do not. Thank you.
I also don't have any questions. Mr. Marsh, do you have any redirect?
Yes, if I may.
Go ahead.
Excuse me. Mr. AAA, do you know how long the KL Beaver number 2 well has been on Keto's inventory?
I do not.
Would that information be contained on the commission's risk-based data management system?
Are you the RBDMS?
Yes.
Yes.
Okay, I should be sharing my screen. Can you see the RBDMS well directory?
Yes.
Okay, can you read this information out loud, please?
Yeah, the API number for the KL Beaver 2 is 15-019-20555-00-01. And then the operator changed from, do you want me to continue? Mr.
Could you
Marsh?
read the comments, please?
Okay, comments. Operator changed from 6321 McCann Drilling Incorporated to 33594 Quito Inc. on 1/6/2017.
So would it make sense that this well was transferred onto Keto's well inventory at the beginning of 2017?
Yes,
Okay. Now you initially inspected these leases back in March of 2022. Is that correct?
that's correct.
So the violations that you found at that time would have been made aware, or operator would have been made aware of those violations at the time that staff filed its report pursuant to the commission's order.
Yes, that is correct.
Do you recall when that report was filed in this docket?
Was it September 7th?
That would have been when staff filed its direct testimony. I was talking about the commission staff report and further investigation. Would it help to pull up the docket page?
Yeah, if you could bring that document up.
Okay, can you see the docket page?
Oh, okay, yes.
And what is the date for that commission staff filed its report and further investigation?
4/29/2022.
So is it feasible that operators known of these violations since April 29th, 2022?
That is true. Yes.
Now I know Mr. Dooling earlier talked about TAs that needed to be revoked. Do you agree with him that select TA applications need to be revoked or reviewed?
I do agree with Mr. Dooling on that.
And then I know Mr. Horst asked about staff reaching out to operator about outstanding compliance issues. Did Mr. McCann ever contact you regarding what else needed to be done to obtain compliance?
Absolutely not.
To your knowledge, has he ever contacted anybody else from District 3 staff about what needed to be done to obtain compliance?
No.
How many operators are in District 3?
How many operators are in District 3?
Yes.
Oof. How many? I couldn't give you an exact number on that, Mr. Marsh.
So does staff usually rely on reaching out to every specific operator, or do the staff rely on operators reaching out to them regarding compliance issues?
A lot of the operators reach out to our district office for guidance on what needs to be done or how they can go about something. As far as I'm concerned, Mr. McCann has done a poorly job at that, reaching out and trying to get advice over the years.
Now, did you conduct recent lease inspections here at the end of November, early December of 2022?
Yes.
Did you find any spills during those lease inspections?
At my particular locations on range 11, the wells that I inspected, there was one well that was impacted. And matter of fact, Mr. Dooling was with me. There was a spill reported on Mr. McCann's lease, and the spill was reported by a landowner the day before this. No one called in the spill, and we actually conducted the field investigation on that lease the next day, and there was an area impacted on the Smith Lolly, and there was no report of a spill there.
So the operator did not report that spill?
No, matter of fact, whoever was working for Mr. McCann at the time, the landowner that called the spill in, Mr. Dooling was with me, and I talked to Mr. McCann's employee, so-called employee, about the area, and then it wasn't 30 minutes later that Mr. McCann called me and said that he knew that I was aware of this spill at this particular well, and that he was going to take care of it.
So you had conversations with Keto about the need to report the spill?
Yes. Mr. McCann's been in business long enough that he knows if he has a spill, he needs to report it in the District 3 office.
And yet the spill did not go reported?
Right.
Okay, thank you.
Yes.
No further questions.
Thank you. I think at this time, Mr. Horst, I'm assuming you don't have any recross.
I would just have one recross, and that is
Go ahead.
Mr. Triboulet, when you contacted Mr. McCann's employee about the spill, and then Mr. McCann called you, at that time, did you have any discussion about any other compliance issues on the Smith Lolly lease?
No, did not.
No further questions.
Thank you. I think that reaches the conclusion of examination of Mr. Triboulet. Thank you so much for your time, Mr. Triboulet. You may step down virtually, and you're
Thank
dismissed.
you.
At this time, I believe we are ready for operator to call its witness. And I think we'll go a little while, and if it looks like we're running on, then we'll take a break. But I intend just to move forward at this time. So, Mr. Horst, you may call your witness.
Call Mark W. McCann.
Mr. McCann, may I have you unmute and raise your right hand? Do you swear the testimony you're to give today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. Mr. Horst, the witness is yours.
Are you the same Mark W. McCann who filed pre-filed testimony in this docket consisting of 17 pages? And I believe that was on September the 7th, 2022. And pre-filed rebuttal testimony consisting of 7 pages
Yes,
on October 19, 2022.
again, yes.
Have you had an opportunity to review your pre-filed testimony and the pre-filed rebuttal testimony that you filed in this docket?
Yes, it's been a while, but yes.
Today, are there any corrections or additions that you have to your pre-filed testimony?
Yes, as I recall, there were some corrections.
Do you have your pre-filed testimony then in front of you?
And no, I do not.
Did you bring it, or do you have it there at your office or with you?
I don't think we have that with us at all.
Can you independently recall what corrections are needed?
No, I'm sorry. I don't recall. It had to do with saying something had been done a certain way, but in fact, that was incorrect. That's my general recollection of that.
Mr. McCann, at page 6 of your pre-filed rebuttal testimony, line 16, the question was asked, are Quito's efforts to establish and document compliance with the statutes, rules, and regulations governing oil and gas operations in the state of Kansas ongoing? Your answer was yes. Is that
Yes.
still true as of today's hearing date?
It is.
Okay. Have you had an opportunity to listen to the testimony of Ryan Dooling?
Yes, I have.
And have you learned anything new that was not contained in your pre-filed rebuttal testimony or pre-filed testimony?
Objection. This seems to be additional direct testimony, and staff would ask that such questions be made on a redirect if within the scope of cross-examination.
Mr. Horst, any response?
Commissioner French, just to note that many documents and records have been filed and much work has been done since the pre-filed testimony, which Mr. McCann will need to testify to, but if we want to procedurally do that on recross, that's fine.
I mean, that is generally my preference. We have taken a lot of additional information and testimony. I think if you have 1 or 2 questions you want to ask regarding current compliance and information or efforts that have taken place, why don't you go ahead if it can be 1 or 2 questions. If it's more than that, I would hope you could maybe expand more on recross.
Very good. I can
Or
keep
redirect, sorry.
Very good. I can keep it to a couple of brief questions. Mr. McCann, has Quito Inc. engaged in substantial efforts to attempt to become fully compliant with the statutes, rules, and regulations, in your opinion?
Absolutely.
And as of this past Thursday, December 15, 2022, what was your understanding about whether Quito was or was not in compliance with the statutes, rules, and regulations?
Myself, with the help of 2 of my assistants, carefully went through the inspection reports that were received in March. Our objective was to address every single issue and to comply with those issues that were presented to us. We did about over 55, or we bought over 55 new electric motors to replace motors. From the date of that inspection report clear up till last week, we were endeavoring to satisfy all these requirements at all points. In what we're instructed to do, it said in there, you must either return to production, plug the well, or file TAs. We return some to production, and we file TAs on others. As of last Thursday morning, I thought we were 100% compliant at all points. Our mail comes in at 1 o'clock on weekdays. With the opening of our mail, we find out that two of our TAs we applied have been denied. That was the first indication that I had that everything was not perfectly in alignment. On that afternoon, I reached out to Ryan Dooling to discuss with him why those TAs have been denied. His rationale was one of dealing with the fact that the wells have been out of service for a period of time, he believed, greater than 10 years. So in all of my prior dealings with the Corporation Commission, we would file a TA, and the actual date that the well ceased to operate was not nearly as relevant as now Mr. Dooling has made it. So he is now saying, hey, if you file a TA and a well has been out of production for 5 years, then you've consumed 5 of your years towards the maximum of 10 years, even though the regulations don't state that. The regulations say that after, you can only renew a TA 10 times, and then after that, you have to file for an exception. Mr. Dooling is reading into the regulations something that I've never heard applied. And by the way, I've been in this business for over 40 years. And something that the other operators in our area I visited with have never heard of. And that is basically backdating the TA date. So following that logic, if a well had been out of production for 9 years, you filed for a TA, that TA, you could only renew it once because it will be at the 10 years. That's a whole different standard that I've never heard of before, and I disagree with wholeheartedly. If a well is not in TA, the KCC normally sends a notice of violation letter, and with that notice of violation letter, they'll give you 30 days to resume operations or file a TA or plug it. No such letters were generated. We just find out afterwards here that our TAs are going to be denied for this reason. But what's most important about that is the fact that I didn't know that even on 2 of them. I didn't know that until last Thursday afternoon, and I immediately called Ryan Dooling. He was going to check some records to get back with me, and he did. He followed up and he called me on Friday. That's when he exchanged this information with me. So from there rolling forward, I knew we had an issue on 2 TAs. But then now this morning, at 7:50 in the morning or so, a huge stack of additional information has been now received. So I don't even know what's in that stack. I haven't even looked at the first page, and neither has my counsel. So we have expended a huge amount of effort. In today's world, there's a shortage of qualified personnel, and so that makes everything doubly difficult. But it's been my attempt, and what I thought I had accomplished was to be in full compliance prior to this meeting. And so I am floored that now we're all of this. Additionally, I disagree directly with probably 25% of everything Ryan Dooling said, that he is not accurate, he is not correct, he is not updated on information, and he said a whole lot of things that were just wrong as could be. Mr. Triboulet, I appreciate Thad. He and I work together. We talk frequently about day-to-day operations. I found him to be very professional and a good man to work with. Although I can see today that he doesn't have sharper recollection of some of these things. I know he does a lot of stuff day in and day out, but there's a couple things in his testimony that we need to discuss also. But the bottom line is, I thought we were in complete compliance. Last Thursday morning, I thought we were in complete compliance. Thursday afternoon, I thought we had 2 issues. Today, I find we have a handful of issues. I have asked And I have asked to, to try to have a meeting. Actually, Mr. Dooling, in my last conversation with him, said that he was going to send an email to his superior, who is Troy Russell, and suggest that we have a meeting for compliance to discuss how we can address all of these issues. But he told me that that probably won't take place till after the first of the year. But I'm totally on board for that. Whatever needs to be done, if it's within the regulations, we will do it. What's at issue right now and has been very hurtful to us, and for reasons I completely don't understand, we have not been given access to Kohler. We've been allowed to continue to operate and with a, de facto license, but not an actual in-hand license. So we can't get access to Kohler. As a result of not being able to get, and by the way, on the access to Kohler, we applied to the commission for that. The commission granted us that. And then Kelsey Marsh filed a motion for reconsideration, took it back away from us. But that has had an economic impact on our companies and our ability to fulfill the requirements of the Corporation Commission. Because without access to Kohler, we cannot qualify for our severance tax exemption. So all of our production, we can't file for the exemption due to this non-access to Kohler. So it's kind of like, for reasons I don't understand, the KCC staff is working against us to prevent us from being able to meet these requirements, which I want to do. We want to do those things. But they're tripping up our money and, making up new rules as we go along. Just briefly, the concept of filing for a TA and having surface control, until this matter that we're presently involved with came up, I've never had to do that before. That's a new thing that came up. That's not in the regulations, but they decided that was it. It's probably a good idea, but it wasn't a regulation before. So that caused the need to refile TAs with evidence of being with surface control. So I don't know, it's been a very stressful thing. I've lived with this in my life every day since March, trying to reach a conclusion. And now I find out that we're miles apart on some of these things. And even to the point that the KCC now is saying that even the TAs that we've already approved, submitted and formally approved, then now they want to revisit those. I mean, when does it end? When can, so they do that and then there's something else. And, it looks to me like if you got approved TA, it should be approved and not subject to revision. I would challenge Mr. Marsh to be able to provide an example of any other well they've granted a TA on and then have later rescinded the same TA. I've never heard of such a thing. So it's kind of like playing Monopoly with my cousin. Until I read the inside of the box and knew the rules, he won every time because he changed the rules to his advantage constantly. That's what I'm seeing. Difficulty like that. I'm trying to comply. They change the rules on and on and on. The issue of the radius around our injection wells, those wells that are outstanding were there when the injection wells were approved 20 and 30 years ago. The other thing is, some of these injection wells are in deeper horizons than the wells in the parameter of the wells. None of that investigation has taken place. Just a throwing mud at the wall, hoping some will stick, and let's attack him because there's a well within a quarter-mile radius of his well, even though the well within a quarter-mile radius is in a completely different, deeper horizon. A whole lot of less than fully baked thought has gone into this. And I am simply an operator, third generation oil field, simply an operator that wants to comply with the regs. And if I can have a clear understanding of that, I will do it. I will do it. They talk, that mention was made about how that, how that we didn't file TAs. Well, prior to this, we had filed many TAs. This isn't our first go around of TAs. We have several TAs we previously filed. Our operator's license, they refer to our operator's license as a benchmark for determining certain factors. That operator's license certified inventory list is over 2 years old. Since I don't have a new license, that hasn't been updated. We have now sent a correction list in that identifies every well in its current actual status. But so anyhow, I just feel like it's government running over business people who are trying, but other operators, I know everybody. I've been at this a long time. My gosh, if right now, if a KCC guy would let me take him, I could show him 100 wells in violation tomorrow. They're everywhere. But my company is under a microscope. Well, I can deal with that. We'll get things right, but I've got to be given an opportunity to get things right. And, and I'll do it. I'll do it whatever it takes. I mean, I'm not going to die on the vine here. Well, I will comply with the regulations, giving the time and a clear, I don't even know what I'm in violation of right now. The information's coming in, I just don't know. So how can I acquiesce to that? Or how can I oppose it? Or what can I do about it? I don't even know yet. So I would like for the commissioners to take that in consideration, that I'm a businessman, I employ people, I pay taxes, I jump through all those hoops, and plan on doing a lot more of it. There's a lot of leasehold here, drilling to be done, and money to be made, and people to be employed. But I just wish I could come to some sort of a solid understanding of what the rules are, and things to be in a timely fashion, and to give me adequate time to get into compliance. So ultimately, what I perceive is that we need to quantify what is still outstanding, because they've acknowledged today by testimony we've moved forward and we've conquered a slug of that, but we need to establish what's left to do. And I would like the commission to enter into an agreement with our company, giving us so many per quarter, something like that, to bring into compliance until we can accomplish that. I'll do everything within my power to meet those goals and deadlines. So thank you very much for listening to me.
All right, thank you, Mr. McCann. Mr. Horst, I feel like we gave a good amount of leash there for you and your witness to add some additional direct. I think at this time, if you want to go ahead and move for admission of the pre-filed testimony, then we'll move on in examination.
Keto Inc. would move to admit the pre-filed testimony of Mark W. McCann and the pre-filed rebuttal testimony of Mark W. McCann. Would thank Mr. McCann for his additional testimony, would admonish Mr. McCann of our discussions prior to the hearing that he needs to limit his answers to the questions asked. I know he desperately wants to tell the commission his story. He'll have an opportunity to do so. Thank you, Commissioner.
Any objection to admission of the pre-filed testimony?
No objection.
All right, the described testimonies will be admitted into the official record. With that, we will move to cross-examination. Mr. Marsh.
Thank you. Good afternoon, Mr. McCann. Now, the license application in question was submitted by you on June 1st, 2020. Is that correct?
That sounds about correct.
Okay.
I don't remember exactly, but about 2 years ago.
Okay, I'll just go ahead and share that screen. Does it say license renewal application detail at the beginning,
Yes,
at the top of the page? Okay, and it says submitted by Mark W. McCann, June 1st, 2020. Did I read that correctly?
That's correct.
Now, as part of submitting your license application, you answered a series of questions. One of those questions was, have you as an individual, partner, or officer had a KCC Conservation Division license revoked, suspended, or not renewed by the commission? Did I read that correctly?
That's correct.
And you answered that with a no, correct?
That's correct.
And then Also, later on, and there's a question that says, are you in full compliance with all Kansas Corporation Commission rules, regulations, orders, and enforcement agreements? Did I read that correctly?
Yes,
And you answered that with a yes.
yes.
However, isn't it true that at the time this license application was submitted, your license was suspended for non-compliance with 2 commission dockets?
You'd have to refresh me on what the dockets were.
I believe they were 19-3271 and 19 CMS 3272 CPN.
Yeah, can you show me that? Can you show me that?
Sure. So I'll pull up what I've marked as exhibit KCC cross-1, which is the KCC licensing data for Keto Inc., license number 33594. And Mr. McCann, am I correct in reading on March 9th, 2020, Keto Inc. was suspended in docket 19-3271 and 19-3272?
Yes, I don't know what that's referring to, but I think I know what that's about.
And Keto was not unsuspended until July 28th, 2020. Is that correct? Or did I read that correctly?
I don't think so.
Mr. Marsh, could you zoom in on that document a bit more? Thank you.
Sure. Does this document state that on July 28th, 2020, unsuspended?
Yes,
Now let's look at some of the other licenses that you've previously had. One of those is McSee Oil Company, license number 31411. Is that correct?
I would agree that oil company name seems to be correct.
And you're listed on that license, or it says PR Mark McCann and EC Mark W. McCann.
I don't know what the EC and PR mean.
I believe EC is emergency contact and P is partner or potentially president.
Yeah,
Well, look, see, it says there at the bottom, PR is partner, EC is emergency contact.
okay.
And does this line state on January 26, 2016, license suspended per docket 16-361? Did I read that correctly?
Just a second. Yes, I think so.
Okay. And then there's another license, McCann Petroleum Inc., license number 7638. And did I read correctly, or does it say that on January 26, 2016, license suspended per docket 16-275?
I don't recall that license ever being suspended. I think we just decided not to renew it.
Okay. Now, I realize that you're not listed on this license technically, and that there's a Dean McCann listed as the emergency contact. Who is?
That's my deceased father.
Okay. Now, I do have some documents that I've pulled from the Kansas Secretary of State. And is it correct that you were president, secretary, and treasurer at the time that that company was dissolved?
That's what that, yes, appears to reflect.
Okay, thank you. I would ask to admit exhibit KCC cross-1.
Any objection?
Object as to the McSee license information as not relevant. Same with McCann Petroleum Inc.
I believe those are relevant in that in the license application filed by the operator, it states that have you as an individual partner or officer had a KCC Conservation Division license revoked, suspended, or not renewed by the commission, with the answer being no. This evidence goes directly against that.
And Mr. Marsh, just for the record, where is this document housed?
Which document? Sorry.
Up on the screen that you're asking for admission of?
This document is housed in, I printed this off of the commission's RBDMS database system. So I would also alternatively ask that the commission take administrative notice of its records.
So that's what I'm going to do. I'm going to take notice of this as a commission record. To the extent the commission finds it relevant, we can discuss that in an order.
Thank you. Mr. McCann, does Keto have well files for each of the wells on its license?
Generally, I would say yes. But there could be some lacking.
Okay, and lacking in what way?
Maybe there's a gamma ray neutron log, but no ACO1, or, maybe there's not a cement record on a well or a fracking record, or, the files are generally complete, but they are not perfect.
Okay, so generally speaking, what type of documents do you have in your well files?
We generally would have the construction of the well information, the driller's log, the cementing records, the perforating records, the fracking records, the ACO1 completion record, other associated paid bills and things like that.
Okay, would there be any documentation showing the date the well was last in production?
And yes, they're unfortunately not very well kept, but whenever we work on a well, we attempt to create records, and there are some records showing, we call them well service reports, when a well has been worked on. And by worked on, I mean subsurface, like tubing and rods pulled out, pump repairs, things of that nature.
Okay. Would you say that you generally have that information for all your wells, or would you say that's information's mostly lacking from your wells?
A little from column A and column B.
Okay. Just as an example, I'm going to pull up a temporary abandonment well application from that operator marked as MCF 003. Mr. McCann, can you see that temporary abandonment well application?
Yes.
Now, on the shut-in date, you put July 20th, 2022 EST. What does the EST stand for?
Estimate.
So if you have well records that would show the date a well last produced, why would you have to estimate the shut-in date?
Must not have had that information on that well.
Would you say that that's a common occurrence to put a July or August date with the EST after it in the most recent temporary abandonment applications filed by Keto?
I think that date or approximations of that date was chosen for that. I guess now in hindsight, we didn't give much attention to the shut-in date. Kind of figured it about 90 days after the inspector said it needed a TA as a rough number for that. This is not something that is standard to us. What is standard to us is a notice of violation letter instructing us that a well needs a TA. So, and from that, there'll be the date, we were observed on such date, and typically operators just back that number up 90 days that from the date they got the notice of violation letter and roll forward. And the shut-in date is not an accurate number. It's a guesstimate. That's why I wanted to make that clear. We're estimating that date. The actual date, I don't know for sure, but I hope that answers your question.
So just to piggyback there, you don't know the date the well was shut in?
I do not know the exact date the well was shut in.
Okay. And Mr. McCann, I know you mentioned something about normally receiving an NOV letter. Are you familiar with the commission's rules and regulations regarding temporary abandoned wells?
Well, generally, yes. If a well's been out of production 90 days, if the equipment has been removed and a well's been out of production 90 days, then a TA is necessary to file a TA. And, but I'm going to tell you, the producers as a whole, they don't want to do that. They'll sit back and wait until they get the notice of violation letter, and then they will act upon that. The people I am familiar with, which would encompass probably 36 operators, no one's volunteering information like that. It comes as a consequence of a notice of violation letter.
Now, whenever you receive an application or an approved TA application, those applications have an expiration date on them, correct?
They do.
So, and that expiration date is going to be 1 year from the date of approval, generally
Correct.
speaking.
Correct.
So why?
Just that logic right there, Kelsey, that doesn't tie to your shut-in date theory at all. What triggers a TA starting point is its approval date.
Well, I think we'll have to agree to disagree on that one, I guess. But back to the kind of question that I was aiming for was, earlier you stated that you generally wait for an NOV to appear before taking some sort of action. So you're saying you wait until a TA expires and you get an NOV from district staff before filing another TA application?
No, if we have a TA on file, normally a month or more prior to the necessity to renew it, we'll get a letter from District 3 advising us of TAs that are facing the necessity to renew. And we comply with that deadline.
Okay. I noticed earlier you talked about wanting to set up a meeting with District 3 staff about KETO's compliance issues, correct?
Correct.
But you stated also that you thought as of last Thursday, KETO was in compliance with all the commission's rules and regulations. I guess my question is, what would be the purpose of such a meeting if KETO was actually in compliance, as you stated?
That was there. I'm glad you brought that point up, because that is a fine-tuned point that needs clarification. Thursday morning, it was my understanding we were in compliance. We had done everything. We submitted all our paperwork. Thursday afternoon at about 1 o'clock-ish, we get our mail. That's when I found out 2 were in violation. I called and talked to Ryan. We were able to discuss one of them. He needed to do some further checking to be able to discuss the second one. The next day, when I talked to him about those 2 issues, that's when, the next day when I talked to him, that's when we discussed the necessity, because he felt like that there, I don't know, we didn't exchange any specifics, but he felt like that, and we discussed the fact that whatever needed to be done, that 30 days time, for example, those 2 TAs that were declined, or to go in there and to put those 2 wells back on the pump, we can't put 2 wells on the pump in 30 days. No way. They don't have enough personnel. Can't hire enough personnel. Can't hire enough contractors. Can't do anything to be able to deal with those short-term deadlines. So we discussed that. So that is the pretense for the meeting that he mentioned, the meeting that he mentioned that we could have after the first year with Troy Russell and come up with a plan to be able to fully quantify and execute a solid plan to be able to overcome these other issues.
Okay. Now I want to direct your attention to the detailed response to commission staff report and further investigation, as well as Exhibit B of your pre-file testimony submitted on September 7th. Can you see both of those documents on the shared screen?
Yes.
Okay. Now I just want to kind of run through some of this, hopefully quickly, for the sake of time. Now I noticed on the Anderson one, you said a CP 111 has been prepared, but that well was not
That
listed
needs to-
on Exhibit A, correct?
No, I'm trying to understand what, this is our list that we generated, right? I have my assistant here that's helping me. Oh, yeah, the pre-filed testimony list. I haven't looked at that since it's been filed. I'm really, it probably would be more confusing than helpful to you. But the Anderson list here, starting with the Anderson, we can sure go down well by well. I'm intimately familiar with each of these wells. Although we need to scoot it over some because on the left side of my screen are myself, Commissioner French and Kelsey, and I can't see it. So if the Exhibit B could go away, we could sure look at the other.
How's that? Is that a little bit better?
Well, it's not complete.
Because I want to be able to reference both of them at the same time. That's why I have them pulled up. And basically it's, my question is the Anderson one, it says a CP 111 has been prepared. However, that well is not listed in Exhibit B, which is wells upon which temporary abandonment applications have been filed. Is that correct?
Like I say, I can't see the whole thing on my screen, but what we're looking at here is the exhibit of the pre-filed testimony, which I would say, I can attest to the accuracy of that today. It would take time of reviewing point by point. I know we said there were some things that were corrected. It could be from that. Going back over to this other list, what is this second list, which is on the right of my screen headed? This is our detailed.
That's the detailed response
Okay.
to commission staff report and further investigation.
All right, so I guess ask me a question and I'll try my best to answer you.
Okay, do you have a paper copy of this document in front of you?
No, I don't. I do not.
Okay. Well, my question is, the Anderson one says inactive CP 111 has been prepared. However, that well is not listed on Exhibit B of your pre-filed testimony, correct?
Yeah, that is incorrect. No TA was ever filed on that. That well has been returned to operation.
And with the Anderson 3, it says a CP 111 has been prepared. However, that well is not listed in Exhibit B.
Not listed over there, and that is incorrect. There was no TA filed. It is in fact, but both of those wells have been returned to production.
So are you saying that some of the information provided in your detailed response was incorrect?
Yes, I think we covered that earlier. Yes.
Okay. Now I could go through this and I think there's several wells listed in the detailed response as a CP 111 being prepared, but none has been filed and the wells are certainly not listed in your Exhibit B. I guess a few others that I want to highlight or hit on, if I may. I want to scroll down to the Doty lease. And the Doty number 3. Now the Doty number 3, it says a CP 111 was approved 10/25/2022. Did I read that correctly?
Right.
Should that 2022 be a 2021?
I don't know, but we have that TA, came through on the list of ones that need to be renewed, and that's been submitted for approval.
But it has not been approved at this point in time.
Actually, yes, we now have a TA that has been approved. I'm seeing here that it is going to be good until January the 21st of 2023.
Okay. Moving on down the list, on the Flossie White number 21, you state that the well needs to be added to Keto's well inventory. Is that correct?
Yes, and we think we've sent letters to that effect.
Has Keto filed a T1 to add the well into its license?
We sent document, we contacted the department and we sent a letter with a list. I don't think on a T1, but a list of all of the modifications and on the same, modification of status of wells. And also on the list was wells that needed to be added. By the way, this Fosse White 21, while we're on it, so we don't lose it, it was not on our inventory. It has been added to our inventory now, and the well is fully equipped and has operated, which was information that Ryan Dooling testified to, that it was, needed a TA. And in fact, I guess he hasn't seen it since he was there last, but within the last couple of weeks, that well's been, is fully equipped and has operated.
Even though the well is not on your license yet?
Well, we've submitted it to be on our license, and in the paperwork, the original paperwork from March, it was assessing that it was not on our license and that it was within the quarter-mile review of our injection well. So it, I just decided we'd go ahead and put it together and take responsibility for it.
When was that letter sent?
My assistant's looking. I'm gonna approximate within the last 2 weeks.
Okay. So you know that the well needs to be added to your inventory since roughly June, and did not file anything did not submit a letter until the past 2 weeks.
I had to decide if I definitely wanted to add it. I had to do some due diligence to make sure I wanted to take responsibility for it, because prior to me taking responsibility, I had no responsibility. So yes, additionally, let me just say that this is a whole lot of paperwork and a whole lot to get straightened out. And so it's taken some time. It has definitely taken some time. I've also had some assistance, clerical assistance that was not of any assistance. So I've got somebody now that is qualified, that is able to help us, and we're creating computer programs to be able to track with the necessity of TA filing. We're keeping close track now of when wells have operated, and we're going to be a lot better organized moving forward.
Mr. McCann, are you aware of how wells are added to an operator's license?
Well, I know it takes the API number, it takes the spot location, maybe longitude, latitude. Those are some of the things. And then it's got to be classified as what type of a well it is. But in general, that's what I know about adding a well.
And that's filled out on a form approved by the commission, a transfer of operator form, generally speaking?
Well, yeah, like hopefully when we can get our license formally renewed, yes, it would be on there all correctly and properly. In the limbo we're at right now, it's confusing how to even add something to a license when half of the state won't even deal with this because we're not on Kohler. We're referring to the KCC itself and referring to the severance tax department. Okay.
Now, I skipped over the KL Beaver number 2 well. I wanted to backtrack to that one real quick, if that's okay. On your response, you say that well was inadvertently included on Keto's inventory list, correct?
That is correct.
However, as we discovered through Thad Tribulay's testimony, that well's been on Keto's license since 2017.
It's been a mistake that has been replicated many times.
So at what point does something not become a clerical error if it keeps being included over and over again?
That is a very astute and interesting question, but thankfully I have an answer. It becomes that at the point in time that somebody observes the mistake. that is what's happened here, and that's why we have sent in documentation to correct that mistake.
And you would agree with me that operators are responsible for observing any mistakes on its well inventory, correct?
Well, I would say that yes, the licensing department and the operator should work hand in hand to affirm the accuracy of that.
Let's scroll down. Bear with me for a second. I'm going to scroll down to Solomon number 5. Now, in your detailed response, you stated that this well's been plugged, correct?
Yes,
However, haven't you not, or has Keto not filed a 10-year TA exception application
there's a
for that well?
confusion there. It's number 3 that's been plugged, and number 5 we're filing for the extension.
So that well was in fact not plugged, correct?
Not number 5. Number 3 has been plugged.
Okay. Now, I also noticed that Appleby number 1 and Appleby number 2 have both recently had their CP 111s expire. But Keto has not filed temporary abandonment applications for those 2 wells, correct?
No, they were listed a while ago as Ryan Dooling as having been approved in his testimony.
Okay. I want to jump to.
Now, hold on a second. I remember something now. He went through them all except number 6. It was denied for some reason, but the others were approved. That's my recollection.
And since we're here on the Solomon wells, the TA application for the Solomon 60, the 61, and the 6 were all denied, correct?
And initially they were denied.
And they're still denied, correct?
I don't know. I don't know that. We were told to resubmit. The testimony today was from Ryan was quite a bit out of line on that. First off, the picture of the water spraying there, that's fresh water from the city of Sedan. That's not salt water. So there's no spill to report there at all in that. And we would never be partaking in spraying salt water on the ground like that. That is fresh water purchased up from behind the post office. It takes, anyhow, you put quarters in a machine and it gives you fresh water. So I can't believe I was accused of purposely spilling and all that. That's not the case. So also he said, Ryan said that the wells there were enhanced recovery wells, EOR wells. And in fact, that is true on 2 of them, but one of them is an actual disposal well. So he misclassified one of those wells. The reason our TA was denied was because we were told that we had to reintroduce water within 30 days. That was the order. So this is how we did it. We hauled water out there. We pumped 7 barrels of water down each of the 3 wells. And we submitted many pictures, not just this one deflammatory picture that's been misrepresented, but we sent pictures and confirming that we had introduced water as we were ordered to into these wells. And it's an interesting concept when the lease has 1 well that produces, 1 production well, but the production well has an approved TA. So consequently, there is no water to produce, no water to dispose of upon the leasehold. So we've got permission not to produce water, but yet we're being critiqued because we're not putting water down the wells. So without access to produce water, we hold water to location and introduce wells. And when we file our annual report, the water we put down in the month, it requires that you talk about the volumes of water, pressures, and the dates that you applied it. So this next year, that will be on our injection report, which will verify we have put water in there at this point. So anyhow, I wanted to bring all those things to light that in my mind, the Solomon lease is 100% in compliance. All that we still have outstanding is our well number 5 that we've applied for the 10-year exception on. And I know you're working with Mr. Horst on that.
Now, you've stated today that you've taken fresh water from the city of Sedan and placed it down these Solomon wells.
Absolutely.
So you're aware that as a condition of your permit, the water can only be sourced from certain locations, correct?
No.
Okay. Well, that looks funky. Okay.
Now, let me give you an example, Mr. Marsh.
Now, my next question, Mr. McCann, is, do you see this page that I pulled up?
Yes.
Okay. Under this paragraph, read silently as I read aloud. It says, fluid desired to be used for injection is salt water produced from the Wayside, Marmaton, and Mississippi formations, and recycled water from any well or wells that may be drilled on the following described leases. And that says the Solomon lease, the east half of section 18, 35 south, 12 east, correct?
Correct.
Okay. Thank you. No further questions.
All right, thank you, Mr. Marsh. We will now move to commissioner questions. Commissioner Duffy, do you have any questions of this witness?
Yes, thank you. Good afternoon, Mr. McCann.
Good afternoon.
You just stated that your company bought 55 electric motors. Are they all installed? And when did you buy them?
We bought them starting within the first month after we got this notice of wells that need to be returned to production.
What month was that?
April, May.
So are all the motors installed?
Yes.
Okay. So you also discussed that you had a meeting with your staff of 2 people. When did that occur?
You're referring to the meeting we had just discussing our plan to deal with these violations?
Yes.
Yes, that happened latter May, early April.
Okay. Right. Are you like a part-time operator? Do you work in a factory or a retail store or have other businesses?
Well, I have some other business interests, but I'm an oil producer, Kansas, Oklahoma. I'm primarily an oil producer, but I do have some other businesses.
Okay. So I noticed that on one of the leases, your father's name was mentioned. So
Yes.
you've been in the business for a while then.
Well, I'm 61 years old. I started out working for my family when I was about 14 and been at it ever since.
Probably driving a truck and doing whatever else.
Oh, yeah.
asked.
Yeah.
Okay.
We didn't even know what a truck with an air conditioner was.
Okay. So I get a sense that, correct me if I'm wrong, that you're a little flummoxed by some of these rules and regs and statutes that are on the books. And so it just seems like you're somewhat like they're new to you. And 2, I really get a sense that you've had these properties, these leases for years, and yet your inventory list that you as the owner operator is not good. In fact, it's poor.
Commissioner, if I could comment on those two things you just said.
Okay,
The first thing, no, I'm not opposed to the rules or regulations at all. I want to comply with them. What I'm having some trouble with is the new unprecedented application of some of those rules, such as the filing for a TA. What's the starting date? You know, I'm just not aware of that. So yeah, I understand all the rules and regulations, and yes. The other thing, yes, I'm going to openly admit 100%, I've done a poor job of keeping my inventory list correct. Just in the in and out day of things, I delegated that to others. And yeah, I'm not, it's my responsibility. I know I'm not trying to hide behind that, but you know, you give somebody a letter and say, mail it, and you think they mailed it, but there's mistakes made. And I did not fine tooth comb each one of those things. I have now, of what we've resubmitted, I have, but along the way, I guess, you know, in the crunch for time and there's other responsibilities and things to get done, I could have done a better job on that. I would openly admit to that, and I am apologizing for that.
okay, so let me ask you about the spills. You're stating, I believe staff identified that there were 3 spills on your property. Are you stating that those spills were not spills and they do not exist?
No, I from what I recall, they just said 2. But once we weed out the fresh water as being not a spill, one of them, yes, there was a leak at a stuffing box. I got a call from the landowner telling me about it. I dispatched personnel to the location quickly. There was a small amount of leaking around the stuffing box. I think I normally have them send me pictures of this. It was de minimis and was not of a size that I considered reportable. Normally, I also deal with the EPA in some of my areas, and normally a spill of a barrel or less is not reportable. And so this would be a spill in a few gallon range. So we cleaned it up. We took an absorbent, which is mostly peat moss, that is excellent for absorbing oil. We went to the location. I was in communication with Thad. We put that on there. They were there. They were completely satisfied with what we had done. Then while they were over on the Smith Lawley, which is adjoining there, well number 3, they also reported it wasn't a spill. There was nothing leaking. It was just some stain on the ground that maybe was exaggerated some by recent rain or something, but it was a little bit of something, a little bit of a stain. It wasn't like, hey, we come out there and it's just leaking all over the place. No leakage, nothing was fixed. It was just some old residual oil. And he asked me, Thad did, he said, while you're out here and you got your man, could he go over there and put some of that absorbent on there? I said, you bet we could. We had done all of that from the time that Thad contacted me, 45 minutes later, all that was done. And I reported that to him after we'd completed it.
You reported verbally in writing? Or
I called Thad.
You called.
I called Thad and I told him, he and I interact a lot. And so, well, not, maybe every week or 2. So he's calling, telling me of a problem. My standard thing is I'm going to go address that problem and I will report to you when it's been taken care of. That's exactly what I did. The whole thing start to finish on that deal was an hour tops on both of those. There was also an incident on our Williamson lease to where he called and he told me, hey, there's some water in the emergency overflow pit there. And what had happened, presumably by the wind, a siphon line had blown out of an oil tank and was putting water into an emergency overflow pit instead of the tank. I was out there hour and a half from the time he told me about it, got it reinstalled in the tank, got it secured where this problem will not repeat itself. And we pumped the water out of the pit back into our tank, into our injection system, and disposed of it.
So when you
Also-
say you mean you personally or your staff?
Some of that was me. I went and saw the problem, and then I delegated to others how to remedy it.
Okay,
And all of that was reported to Thad promptly.
okay,
I think-
so let me ask you this. You're telling me that EPA rules specifically state that if it's under a barrel, you don't need to report it? Or is it KCC rules that say if it's under a barrel, you don't need to report it?
Well, I can remember reading in some of the KCC regs where it talks about small amounts, but I cannot specifically recall the KCC saying a barrel. That's just kind of a standard that I've employed. Is that,
All right.
and hey, and by the way, Commissioner, all that changes completely if it enters a waterway, which is not the case on any of these examples.
Okay, so it sounds to me like in earlier testimony that there was some concern that there was not communication between staff and yourself, but now you're talking about weekly or bi-weekly conversations with Thad, and you've talked with Ryan as well. So
Much more with Thad, only a few times with Ryan.
okay, over the number of years that you've operated.
Well, those guys are new at this. I mean, Ryan's only been employed by the commission, I think, for a year, and Thad is a year or two. Thad works our area. So from the day in, day out, if there's an issue, he contacts me and tells me what he's seen and asks any questions, and we exchange information. And then he goes to the forefront of my concerns to report to him that we had satisfied what he is requesting.
Okay, so my last question is this. Are you in compliance with KCC rule and reg, or are you working diligently to be in compliance? I believe was your phrase, working diligently to be in compliance. Which one is it?
Well, as of last Thursday morning, I thought it was in complete compliance. Now I'm finding I'm not, but I am diligently doing the information that we just received this morning. We're going to digest that information. We're going to see what's what. We may have to make some calls and find out what needs to be done, but I want to be in compliance. I don't, that's my goal, is to be in compliance.
Well, I think we want you to be in compliance too, but
Yes, I know.
so you're telling me that when you submitted the documentation, you believed you were in 100% compliance with commission rule and regulation and statute, and but for what you heard back from the commission just Thursday after 1 o'clock, you believed you had satisfied completely all the requirements.
Yes, ma'am. Also, yes, and
Okay.
then even when I spoke with Ryan Thursday and then the following Friday.
Okay, that was the answer to my question. Thank
All right,
you.
thank
All right,
you.
I appreciate it. And thank you, Commissioner French.
Thank you. Well, thank you, Mr. McCann. I don't believe I have any specific questions for you. So at this time, I'm going to ask your counsel if he has any redirect for you.
Commissioner French, I do have some redirect, but I think if we could take about a 5-minute break, I
I'm
could.
happy to. We've been
expedite
going
this.
for a while. Let's break, and actually let's break until 2:40. So about a 10-minute break.
Thank you.
We are now off the record and in recess. All right, we are back on the record. Do we have everyone back? Mr. Horst, I see you're on mute. Do we have you? Looks like we may be waiting for our witness as well.
I'm now back on. Thank you.
Looks like we are waiting for Mr. McCann. Let's give him another minute. There he is. All right. I believe we were just turning to Mr. Horst for redirect. So go ahead, Mr. Horst. We are back on the record.
Mr. McCann, Mr. Dooling previously identified exhibit RD1, which was a list of the wells and 82.3.111 violations. Do you have that list in front of you?
Yes, I do.
Okay. And can you please go through those on a well by well basis and advise the commission as to what action Quito has taken to try and bring each of those wells into compliance prior to today's hearing date?
Yes, I will. Do you want me to start with Anderson number 1?
Yes.
Okay, Anderson number 1, we delivered and caused tubing and rods and a pump to be installed in the well. We installed an engine, and we caused the wells to produce into a portable trailer. I've since just today found out that trailer has evidently cracked and sprung a small leak there. So that will be rectified with a different type of container, or that will be repaired if it's repairable. So that's the status there. We've returned it to production. It has pumped. Anderson number 3, similar type situation without the leakage of the tank. We saw the pictures of that with the tote. It should also be noted, these totes are not an agricultural vessel. All of the totes I have came from Coffeyville Resources Refinery in Coffeyville, Kansas, and they're used for various functions within the refinery. So that's 1 and 2. They both operated. They are both fully equipped to operate as we speak. Beaver number 1 is a enhanced oil recovery well. It was, we were told to file a TA on it, which I believe we did. Is that correct? We did. I believe we did file a TA. I don't know the status of that TA. It's been sent. I don't know the status of it today. Now, it's this one right here, Beaver number 1. So it has a TA, right?
Yeah.
Yeah, let me retract from that. A little bit of confusion between 1 and 1A. Beaver number 1, our notes say it has an active TA that expires 10/14 of 23. So the first 3 wells here are in compliance. The next one is Beaver 1A. Beaver 1A is also known as Clark 5. And so 1A, which is actually Clark 5 by the corrected records, we sent a TA on December the 6th of this year, and we don't know the status of it yet. Darnell 1A, we have an active TA, right? Yeah, we have an active TA that expires on 10/14 of 23. DeArmond 16, 17, and 25. All 3 of those wells have been fully equipped and have operated recently. DeArmond 25, We have submitted a TA on it on the date of December the 6th of this year. On DeArmond 30, we have an active TA that expires 10/14 of 23. DeArmond 31 and 32, both of those wells have been fully equipped and are returned to service. Okay. The next one is DeArmond 33. Active TA expires on 10/14 of 23. The next is DeArmond 35. It's showing an active TA also expiring on 10/14 of 23. DeArmond 38 has an approved TA that expires on 10/14 of 23. DeArmond 39, it's fully equipped and has operated. DeArmond number 6 is a injection well that is we have applied for a TA on. We sent a picture and applied for a TA on 12/12/22. DeArmond M1, the TA was denied. The first reason it was denied was because of the fact that it didn't have surface control. So we went and installed surface control, resubmitted with the picture showing the surface control. That was then, the TA was denied. And that's one of the ones I only found out about last Thursday, denied relative to the shut-in, the date of the last produced date. Although on that one, I believe we have found records that will show that that is within the span of 10 years. So it should, with that evidence, it should now be approved, I would think. DeArmond M12, fully equipped, ready to, and has operated. Mr. Dooling noted that some of the line valves were closed. The reason for that is because these wells, the reservoir is shallow. It's only 950 feet. Sometimes they will pressure up and flow some down the flow line intermittently. So when we're not actually physically operating the well, we shut off those valves to prevent fluid leaving the well without our knowledge. In M3, on that one, we have, where's M3? We have an approved TA that expires on 10/14/23. DeArmond M4, fully equipped and is operated. M5, we have an approved TA. Not M5. We have a TA on M5. Okay. M8, we've returned to production. The OW2 and OW3 are not our wells. They are very, very old wells that predated the lease on this property. Doty number 1 is an enhanced oil recovery well. It's shut in. We submitted a TA. The TA was then declined because there had not been water produced that had been put into the well. So we introduced water, 7 barrels of water into that well, and sent pictures to the District 3 to document that. On the topic of fluids allowed to be injected, even though the fluids to be injected identify the salt water and the formations the salt water can come from, nothing in there precludes the injection of fresh water. And in fact, that is done in numerous places. Water is taken directly out of stock ponds and used for water injection for repressuring. So So anyhow, I think we're well within the boundaries of being able to use fresh water to inject. Doty number 2, for reasons I don't know yet, we submitted a TA on December the 6th. There was confusion on this Doty TA well. Through the maps that were presented to us showing where these different wells were at showed this Doty M2 to be on a completely different leasehold of a completely different operator. I then helped Mr. Tribble find this number 2 well. Now I'm told that it is being denied, and it just says incomplete. I have no clue what is incomplete. That could very well be accurate. There may have been something that was not a box not checked or something. Flossie White 21, that well was not on our inventory. And it was in the 1/4 mile radius of our injection well. So I don't know, just to help out, I guess, I went ahead and took responsibility for it and fully equipped it, sent pictures of that to the KCC showing it's fully equipped, and included that on our on wells that needed to be added to our inventory. The next is Floyd casement number 6. Floyd casement number 6 is not on our leasehold at all. It is not on our inventory. We have nothing to do with it. It's just within a 1/4 mile review area. Floyd casement number 7. We believe a little bit of confusion on where that well even is or what it even is, but it's not on our inventory. And the only reason I think it's mentioned is because it's within a 1/4 mile radius of our injection well. Okay. Graham number 1A, it says in this note denied. I have no clue why it would be denied. We sent a picture of it with surface control. It should have been good to be approved. Graham number 4 is fully equipped and is operated. Graham number 5 is fully equipped and is operated. Graham number 6, it says denied TA. Once again, I have no idea why that was denied. That well is operated. In fact, it wouldn't take much to get that well operating again. But that well has been operated within the last 1.5 years or so. So I don't know what's up there. Graham 40 is fully equipped and has operated. Englefield 1A, fully equipped and is operated. Englefield 19, fully equipped and is operated. Englefield 23, fully equipped is operated. And Englefield 2A denied for its TA. That's after it was initially submitted and denied for not having surface control. Then we installed the surface control, reapplied for the TA, and then when denied because they're claiming it's been over 10 years since the well's operated. I don't fully understand how they know that, but that's their position, and so on. Englefield OW1, OW3, 4, 5, 6, 7, 8, and 8. All of those wells are simply not our wells. They're wells that predated our lease and, probably from like 1910 or so. Englefield 24, it has approved TA. That is good, that expires on 10/14/23. John Casement Nella 1A has an approved TA. And it expires on 11/14/23. LDH Church is active and has produced, number 1. Number 2 is currently in production. Number 3, we had a TA that was approved that expires 11/14/23. And number 5 is also an approved TA that expires 10/14 of 23. M&M Kirchner number 4, which is an injection well. We were instructed to file a TA, which we did. It was rejected because the well hasn't been used in quite a period of time. And the order from the commission said that we had to reintroduce water. We had to start using it again. So once again, this is one of the ones we hauled the fresh water out to and injected. We sent pictures and evidence supporting all of that to the commission. Mary G. Sears 3TK, denied TA. I have no reason why they denied that TA. Mary G. Sears number 4, also a denied TA. Again, I have no reason. I don't have any knowledge as to why they denied that TA. And just what I mean by that is I haven't seen the denied TA. It's just on the list that came from Mr. Dooling, that's how he represented it, was a denied TA. McCann 2A, which is a well that we drilled out. I believe at this point, all of the ACO ones have been properly filed and everything's on track there. McCann, what they're calling number 3, which we called number 2, there's a mix up with well numbering and so on, but we have filed on well number 2 that we drilled it out, and then we filed the ACO 1 on that also. So I would say we need to do a little bit of research to determine if we made a mistake or the KCC made a mistake as to the well, the particular well number at that location. If it's our mistake, we will promptly send in the corrected paperwork. We've become very well acquainted with the younger fellow that works in the ACO 1 department. He's very helpful and has been great to deal with. So we can, if we've made that mistake, it's just a mistake, and we will correct it. McFarland 11, fully equipped and is operated. McFarland number 1, TA denied for reasons, once again, I have no clue why they denied it. We sent the pictures with it, all the control equipment on it, but they denied it. McFarland number 2, it is fully equipped and is operated. It's one of the wells that we went back and put tubing and rods and a pump jack and a motor on and actually returned it to actual operations. McFarland number 3, denied TA. Again, no reason why. McFarland number 6, same difference, no reason why. McFarland number 7 is an injection well, and it was denied. Again, I don't know the reason why. Number 8, fully equipped and is operated. McFarland OW1 is a few hundred feet away from an approved injection well that has been approved since the 1970s. And it's an important well for operation on the McFarland DeLong lease. This OW1, when I first got involved with this particular lease in 1988, the landowner told me directly, took me over in the trees and showed me this well with an old rod line pump jack, if you know what that is. And he said, this well is a freshwater well, and he had plans someday of using that to water livestock or whatever. And he said, I want to make it clear you don't come over and mess with that because that's not yours. And of course, it's never been on our operator's license as far as I know. But the point is the fact that I don't know anything about that well. It was approved for water injection. It has passed its mechanical integrity test year after year after year. And by the way, it has 100% compliance with all mechanical and testing requirements. All of our injection wells are current on our mechanical integrity testing. And So we're not, from the standpoint of looking like a bad operator, I mean, that alone is a significant accomplishment, and we're current with that. We've always been current with that. McFarland, go back to the list on page 14. McFarland DeLong 5, fully equipped and is operated. Morton number 1 is a well that's within the area of our review, but not our well. Number 16, the same difference. 18, not quite the same difference, because 18 has been plugged, and Mr. Horse sent pictures of the plugging records on that to the KCC early on. 19 is fully equipped and is operating. 27 is a well that it has a current TA right now. When they went to visit this well, they found a little bit of water bubbling on the wellhead. It was shortly after it rained, and there was a little bit of water bubbling on the wellhead. Very common. So what I did to remedy that was about 3 or 4 swats with my sledgehammer on the nut that tightens the wellhead, and it was fixed. So for reasons I don't understand, they say due to that bubbling that it now needs a casing integrity test. So actually my plans on it are to return it to production. So hopefully that would completely eliminate the issue of needing to do a CIT test. Morton number 3, that's our approved injection well. It's been in use recently. Morton number 5 is also a well that has been plugged, and it is a well that has been plugged and is not on our inventory, just within the quarter mile of our injection well. M1 is a gas well, and was a gas well. There's no gas market there now. So it's a shut-in oil and gas well. It makes both. And so anyhow, we have an active TA there, right? M1. We had a TA approved, and it's time to renew it. So we've sent that in with a renewal date of 10/6/22. I guess just to briefly touch upon this, they're saying there's been no gas sales for 10 years. And that due to that reason, they're saying that the well is at the end of its 10-year time. But original TA is not more than about 3 years old. And even though the well ceased to produce gas, there was quite a period of time after that we continued to produce oil that it made. It didn't make a lot, but it made a little. Mullins number 2 is that's our injection well. It's active. We've sent pictures in of that well showing that it's active. Mullins number 3, we filed a TA, and it was approved, and it expires on 11/14/23. Sears 14 is what does this note mean? Sears 14 was denied, which I do not understand at all. It has a control valve on it. We were pumping this well clear up to about 6 months ago, and we were going to clean the well out. So we took the tubing rods and the pump jack off from it. Our driller became ill with colon cancer. Hopefully he's going to be back around the first of the year. But that well, I can't imagine a reason why that one couldn't be T8. In fact, it's operated within the last year. So Sears 22, it is a well we've added to our inventory list, and it's a well that we currently have applied for an injection permit for. Sears 24 is active and producing. Sears 25 also active and producing. Sears 25 was not on our operator inventory, and so we've added that to our inventory. Sears 29, I don't believe the Sears 29 well exists. I think it was a permit we filed to drill a well, but never actually drilled the well. Sears 31 and Sears 32, they have both fully equipped and have operated, and pictures have recently been sent. The same with Sears 40, fully equipped and is operated. Sears number 6, not on our inventory. Sears number 7, it has operated within the last year and it's fully equipped to operate. Sears number 8 is not on our inventory. We are, I don't know if we added that or we're contemplating adding that, but we added it. So it's been added to our inventory. And we filed a TA also. Sears A2, we filed a TA on it. It's an injection well. We received a denial saying it lacks surface control. So we went back and installed surface control, resubmitted the TA, and it's been denied again for reasons that I have not yet been made aware of. Sears M2, fully equipped and is operated. Sears OW1 is not on our inventory, and it is a well that it's just a really old well that no one I've been able to find knows anything about it. Sears 3A, also not on our inventory. That brings us up to the Smith Lawley. And on Smith Lawley number 1, it's a injection well that has been approved for a TA that expires on 10/14/23. Smith Lawley number 2 has an active, it's an injection well also. It has an active TA that is expires on 10/31/23. Sears number 3, Smith Lawley number 3 is it was the one that needed that, had that little bit of a little bit of oil, minute amount of oil that we, upon request of the commission, we put the absorbent on. It's fully equipped and is operated. Smith Lawley number 4, fully equipped and is operated. Smith Lawley number 5 is a TA injection well that has been approved and expires on 10/14/23. Smith Lawley number 6. A little bit of confusion with 6 and 7. We've always called it 7, they called it 6, but either way, it's fully equipped and is operated. Smith Lawley number 8, its TA was denied, again, for reasons unknown. It has not been out of production, certainly not for a period like 10 years, but it may have been in production for a couple of years or so. But again, denied TA for unknown reasons. Solomon number 2 is it is a approved, it was a 10-year exception approved well, if I'm recalling correctly. Number 5, right now, we have applied for the exception on Solomon number 5, TA exception for it's older than 10 years. Solomon M1, fully equipped and is operated. Appleby 5, TA is approved. Appleby 6, we've submitted the TA. It's my understanding generally that they didn't approve it, but I don't know why. Tom Appleby number 8 is fully equipped and is operated. Wall number 1 is an enhanced oil recovery well that what are we doing here? Oh, it has an active TA that expires on 10/7/23. Wall 2A is fully equipped. Wall 4A is fully equipped and has operated. Wall 5A, we filed a TA. There it is. Oh, yeah, you're right. 5A is active. 6A, we filed the TA on. It's been approved and it expires 11/14/23. Now we go to the Williamson. The Williamson number 1, okay, fully equipped and is operated. Number 3, TA has been approved. It expires 11/14 of 23. And Williamson number 4 is fully equipped and has operated. I didn't keep a tally going through that, but it sounded to me like the approved TAs and the fully equipped far exceeded anything else. John?
Yes,
Mr. Horst, do you have any further redirect?
you just bear with me for a second.
If I can jump in, can we identify Mr. McCann's administrative assistant, since they were helping him answer a lot of these questions as we were going through this?
You might.
Certainly. Would you like me to do that? Her name
Let
is
her take my seat and introduce herself.
Hi, I'm Kim Wilson. I work in the office.
I guess, can I make one closing comment myself here?
Well, let's wait for your attorney to
All right, thank you.
see if he has any further questions.
again, Mr. McCann, back on page 13 of 14 of exhibit RD1, McFarland Delong 7.
Should have kept these in order. McFarland DeLong, okay.
It's on page 13 of 14. Again,
Okay.
what is that the injection well?
Which one, John?
McFarland DeLong 7.
Yes, it's an injection well.
Okay. And is there a TA authorized on that well?
Yes,
And
it
when
is.
did,
It expires on 10/14/23.
and then on the McFarland DeLong OW1 well, that
Yes.
is bottom of the same page. What is your understanding of what that well was used for?
My understanding is that well, originally this, most all these leases have been drilled, plugged out and re-drilled at least once. And that originally, when Prairie Sinclair owned this lease, this well was a water supply well that delivered water to a tank that was then used in some sort of a steam type engine that would have ran the powerhouse. Turn of the century type thing. Not this century, the last century.
Has Keto Inc. ever physically operated that well?
Never have touched it in any fashion.
Back on the McCann lease, Mr. McCann, to the best of your knowledge, were notices of intent to drill filed on 2 wells to drill out 2 plugged wells on that lease?
Yes, there were.
And do you believe you have those records?
Yes.
And do you believe that they were submitted to the commission?
Yes.
And do you know why the commission cannot find those let me retract that. Were those records submitted to the commission in paper form?
That's my understanding, is that they were submitted in paper form. I didn't realize that they were contending they didn't have them. First off, we know that before you begin operations, you have to call it in and all of that. And all that was done. I mean, we called in prior to beginning to drill out the well, we called in and we notified. Now, I guess they're saying that, they didn't see they don't have them in the records, or I don't know exactly how they keep the records of call-ins and so on, but Ryan kind of tried to explain that. But here's one possibility of an issue. The driller there is Finney Drilling Company. And, I probably, since I didn't know exactly when he was going to start, I probably just told Kurt Finney, hey, notify the state before you start. He's a very experienced driller. He knows that requirement. And so it's possible that it was called in under Finney Drilling instead of Quito Inc. Finney Drilling is also a licensed operator.
Mr. McCann, do you believe your office records would show that 2 notices of intent were filed to drill out 2 prior plugged wells on the McCann lease?
Yes, I thought those were already in evidence. Yes.
Okay. I think that's all the questions I have of the witness at this time.
All right, thank you, Mr. Horst. We allowed some pretty extensive redirect there, so I do want to give Mr. Marsh one final opportunity for recross.
No recross, Commissioner Finch.
Thank you. If there are no further questions from commissioners, I think that we have reached the end of this witness. Mr. McCann, thank you for your testimony today, and you may step down virtually. You are dismissed. Let me see where we are at the procedure. We are getting close to closing statements, but I have got one housekeeping item here. Mr. Marsh, during preliminary items, you raised that you had a number of documents that you wanted to take notice of. I know that there was at least one field report that we did accept into evidence. We took notice of it during questioning, but I'm not sure we got to all of them. Do you have record of, where we are on your documents and whether you got everything admitted or taken notice of that you expected to?
Well, I think I've gotten notice of everything I've asked for, right? I know the commission had concerns about so many documents at a late notice. So I tried to not pile on too much, if that makes sense, and try to point out some things that I thought were necessary.
Okay.
I'll leave it up to whatever you prefer. I mean, if those documents are something that you think would be helpful to have supplement the record, then we're happy to have those or ask for those to be given administrative notice. And, I guess it could be appropriate since Quito kind of came in with similar documents for all the leases. But I'll leave that up to your discretion of what extra documentation.
Mr. Horst, I will give you an opportunity to respond if there's anything you'd like to say here.
The response would be, again, that Quito simply has not had an opportunity to review these documents or to prepare any meaningful reply or response to provide the commission at this hearing. If those documents are accepted, or if the commission wishes to take administrative notice of them, then I think from a fairness standpoint, it would be appropriate to allow, at a minimum, give Quito an opportunity to make some sort of written response to the documents before this is determined. This matter is determined on the issue of whether Quito is in compliance or is acting in good faith to achieve compliance.
I mean, Quito has had the opportunity to go through a well by well basis this afternoon about what its compliance status is. So I don't know that a written response would be really necessary other than just prolong the docket at hand.
Yeah, here's what we're going to do. So one, I do agree we've given an operator quite a bit of opportunity to explain their position on each well. I would also say we were very liberal in accepting sort of late documents from the operator, but given all that, I believe these are all commission records that we house within our own records. I think we can take administrative notice of those at any time during the proceeding, even after the hearing. So what we're going to do is, I'm not going to make any decision on notice of those documents at this time. If the commission in deciding this matter feels that it needs to take official notice of its files and records in its order, we will do so, but will not take any action right now. That yes, I believe that takes us to closing statements. I don't know that you established any time limits for those at your pre-hearing conference, but I expect they could be done pretty briefly. So let's start first with the operator, Mr. Horst.
Thank you, Commissioner French. I believe that today's hearing establishes the substantial effort undertaken by Keto Inc. To comply with the statutes, rules, and regulations of the commission. In light of the substantial evidence indicating Keto's compliance efforts, it certainly would not be appropriate for the commission to deny renewal of Keto's license based on compliance issues. At a minimum, it is clear that any compliance issues are resolvable and are primarily a matter of simply getting the operator and commission staff together to communicate and work through any remaining issues. Commission staff depends upon the voluntary cooperation of operators. This operator is before the commission indicating his not only demonstrating his efforts, but indicating his desire to cooperate with commission staff in achieving compliance. Denial of the license would eliminate the ability of the operator to achieve compliance by deriving the operator of any financial resources needed to accomplish that purpose. It is therefore in the mutual benefit of the commission and the operator to not deny a license renewal based on compliance, but to work with the operator to achieve compliance and to follow the regular approach set forth in KSA 55-162 for that purpose. With that, I think I would conclude that concludes my closing argument.
Thank you, Mr. Horst. Mr. Marsh.
Yes, thank you. Mr. Horst talks about the substantial effort, he calls it, that Keto has taken to comply with the rules and regulations, but that's not exactly why we are here today. We're here to determine whether, Keto is in compliance with all the rules and regulations that the commission has. And I believe that the evidence that has been provided by staff today shows that Keto is more likely than not out of compliance with the commission's rules and regulations. Staff has demonstrated wells that have been and remain out of compliance with the commission's temporary abandonment regulation, whether it's wells that have been inactive longer than allowed by regulation or wells that have had denied TA status. Also, during Mr. McCann's testimony, he talked about wells that have been operated. However, as we heard during staff's testimony, they only found 4 wells in service during their most recent inspection. Just one of those things that doesn't add up. We also learned about wells where spills went unreported and have not been remediated to staff's satisfaction. Wells where Keto is conducting unauthorized injection. Wells that were drilled or re-entered without an intent to drill being filed, or a spud call being made. Keto's failure to timely submit ACO1s for those wells, and Keto's falsification of its certified well inventory. Not to mention the abandoned wells that remain within a quarter mile of its injection wells. Staff believes that evidence requires the commission to follow its statutory mandate and affirm the order denying its license, and staff respectfully requests that the order denying license be affirmed. Thank you.
Thank you, Mr. Marsh. Before we conclude, I want to see if there are any post-hearing issues that we need to address. It's my understanding the parties did not see a need to file briefs. Are there any other issues? Hearing none. This will conclude our hearing in this docket. At this time, we will close the record and adjourn. Thank you all for your participation.
Thank you. Thank you,
Thank you.
Commissioner Guppy.
Thank you, everyone.